Sir, you're charged with especially aggravated kidnapping. You're also charged with aggravated assault, and you're charged with theft of a firearm worth less than $2,500.
You're talking about stuff that is not relevant.
Hello and welcome to the Court of Public Opinion. I am the Recovery Addict, and boy, do I have a case for you today.
Why is the dog chewing on this guy?
I think they have got the wrong guy
They
there.
got the wrong guy, and the dog was biting him.
He roughened him up quite a bit. There's a lawsuit.
This is the next search on February 28, 2020. 7:44 p.m. How period does the FBI find people? And people is misspelled P-E-O-O-P-L-E.
I object.
Did the defendant find out how the FBI finds people in this case? Oh, she found out.
Because he's the guy.
Welcome back to the Court of Public Opinion. I am the Recovery Addict. Happy Wednesday afternoon. Hump day half over. This is officially the halfway mark, right? When we're halfway through hump day, it's all downhill from here. We'll be returning back to court in Canton, where the breaking news right now is that they have, in fact, stopped the fan. The fan has ceased spinning. Is this an indicator of what's coming up? I do not know. But we don't see this very often. But the fan has been turned off. I know. In breaking news, you'll only hear it here. The fan is not spinning. So we'll keep an eye on that for you. All right. People are more upset about the fan than they are about the rights and the wrongs of whatever is happening in court. I had a delicious salad. Today. It's getting hot in here. It is. I had a delicious salad on lunch, and I'm completely energized and ready to go for the afternoon. Ran to the post office. I have to say just a massive, massive thank you to Sloth Life. Sloth Life sent a package all the way from Scotland, and she gifted me a new Scotland Yard pin. You can't see it. It's there, trust me. It says New Scotland Yard on it. And this amazing little box with a brilliant coin. Here, I've got to go full screen on this one. Here we go. And turn that off so you don't. Okay. It looks like this. We're gonna focus nice and tight on it. There you go. London Metropolitan Police Service coin. On the back side, it has a beautiful skyline, London skyline relief, like that. It says New Scotland Yard. That is awesome. I'm going to add this to my my collection, and it will sit in a place of honor. Sloth Life, thank you. And to your hubby, who is a long-suffering hubby, apparently. Thank you very much as well. That is really, really cool. I appreciate that in a big way. That's neat. I spent a lot of time over in London. Never got anything this cool, though. That is really neat. All right. Thank you, Sloth Life. Welcome. By the way, we have to say welcome to Handmade by Wendy, who was first in chat. Now I'm blurry. Ooh. I'm back. There we go. Handmade by Wendy's first in chat today. Wendy, congratulations. And we're going to punish you for it. Yes, you're the internet owner again. You've won before. You've won again. This is going on your permanent record. You're responsible for everything IP related worldwide. It's a small job. Well, it's a massive job, but you've done it before, so it's going to be great. Sloth Life, I just said all the nice things about you. Thank you so much. You have to watch on the replay. I showed off the coin. I showed off the pin. Sloth Life has given me some beautiful treasures from Scotland and from the UK, which sit in a place of honor on my shelf here. So, right next to the pen I got from Rob. This is good stuff. It's coveted space, if nothing else. All right, we are going to be going back to court. I'm actually, you know what I want to do? Let's bring up the replay machine. I want to see if the fan was running at a specific time. Let's see if they just turned it off. Quit that. take a second to launch. Apparently updates are available. My house is shaking from the wind. Is that a bad sign? Like, should I feel the whole thing shake? It's been raining like crazy out there. Now the wind is kicking up. Apparently it gets worse in about an hour or two. That's when it's going to be the worst. Okay, launching our replay machine. Connecting the video. There it is. I can hear it. It's loud. Whatever's happening outside is very loud. Connect more video. Trying to turn everything on. I'm not sure if I turned it off or back on. I think I turned it off. Maybe the battery's dead. Oh, it's on. There we go. All right, let's rewind just a tiny bit. I'll show you this if the fan was spinning at one point. Oh, yes. Look, we caught it. We caught it. Here we go. Right there. This is the breaking news. I'm going to show you this. The fan was spinning, and now it's not anymore.
All right, Mr. Jackson, go ahead and continue.
Okay, here we go.
When we left off before lunch, we were discussing the inverted video. In the moving papers, the prosecution indicates that, quote, the prosecutor had not previously received this video or knew of its existence. This is I don't know if it's the third or the fourth time that the Commonwealth sort of runs to this argument about not knowing personally about the existence of a particular video, but that it doesn't matter how many times they argue that point, it still doesn't change the fact that it prejudiced the defense by not having it, and one of their members, whoever that agent is of the Commonwealth, was lying about having it and not disclosing it. Somebody knew, and the question before the court is, who was it? Who did know? Perhaps it wasn't Mr. Lally. Perhaps it wasn't Ms. McLaughlin. Was it Chief Rafferty? Certainly Proctor had it. He watched it. Who else knew about it? Members of the prosecution knew of the existence of this and other videos, and they hid them. And that's the galling issue. Then the Commonwealth writes that the defense altered, their word, the defense, quote, altered evidence to correct the image, as if we were altering something to deceive the court. When in point of fact, the Commonwealth well knows that that altered video was altered by them in some way, shape, form, or fashion. When it was played inverted. What we did is recorrect it to the proper orientation to confront Sergeant Buchnick with it. They indicate that they played the entirety of the video, of the corrected video, to somehow suggest that the Commonwealth, during this debacle, had clean hands. And that's just not true. Over the course of 2 days, the court will recall 2 days worth of testimony. Day one with Sergeant Buchnick under direct examination by Mr. Lally. Going into the next day, still under direct examination by Mr. Lally, they played that video completely inverted. They talked about it, they discussed it, they described it. Not once did Sergeant Buchanan or Mr. Lally inform the jurors or the court that the video was actually altered, that the video was actually backward. Not one hint to the court or the jury members. When the defense stood up and began questioning Sergeant Buchanan about that video, that was the first time that he admitted that it was inverted. He used the phrase mirror image, and that he knew that it was inverted. Amazingly, that was the same time that Sergeant Buchanan started having trouble with his memory about who was actually depicted in that video. The court will recall before I stood up on cross-examination, Under direct examination by Mr. Lally, Sergeant Buchanan was very quick to point out that the individuals on that inverted video were himself and Michael Proctor. And they made the point that Michael Proctor never approached or had any access to or didn't manipulate in some way, shape, form, or fashion. This was the intimation by the Commonwealth, that passenger taillight. The Commonwealth has now conceded that that person was, in fact, Michael Proctor. It's notable that the Commonwealth went to great lengths to state that, quote, Trooper Proctor, and this is in their opposition, Trooper Proctor is standing feet away from the defendant's vehicle and never touched the right rear taillight, end quote. That's a statement made in their moving papers, specifically on a fact that is of great material importance to this case. The three of them signed, the three prosecutors signed an oath and a declaration, and the court just called the defense out on signing a declaration or an oath. And the court's intimation, at least, in its initial comments to me was, you may have said something that you don't have a factual foundation for. And I think I have done my best to disabuse the court of that we were drawing from reasonable inferences. I wonder if the Commonwealth is going to get the same treatment for saying that Trooper Proctor was standing feet away from the defendant's vehicle and never touched the right rear taillight. That's a very bold statement for the Commonwealth to make, and it's also completely untrue. It's not supported by a single fact. It's not supported by a fact or evidence before the court. The problem with this unsupported motion, because it's unsupported and the declaration is signed by three different individuals, you can just sort of say whatever you want in the motion. And I guess get away with it. The video speaks for itself, Your Honor. It shows Michael Proctor walk behind the car directly to the position of the passenger taillight. He positions himself right on the other side of the camera view, not feet away. And it certainly does not show, and there's no evidence before the court, that he, quote, never touched it. As a matter of fact, we would submit...
Does it show that he does touch it?
Well, of course it doesn't show he touches it, Your Honor. He's on the other side of the car. That's not the point. The point is, a reasonable inference is he could have touched it. He was standing right there. Nobody forced him. Nobody was holding a gun to his head. He walked around the other side of the car and obviously was standing there for a reason. By himself, in a corner, out of the view of a camera, and then when the Commonwealth plays the video, it switched, and the intimation to the triers of fact was he never approached the right rear taillight, that passenger taillight. And all of that was
you cleared that up.
Right. But that is the galling part of this entire thing. The court has asked me a couple of times, and I'm going to get to it a little bit more in detail, what the prejudice is. If that's not prejudice, I don't know what is. It's literally propounding false information to a trier of fact. That is not a small thing. Even after the trial was over, it was concluded, and the mistrial was declared, we're still getting videos that we can't get a straight answer about their source. Where did these videos come from in October? That surveillance feed is on a 30-day deletion loop. That's what we've been told. I said a few minutes ago this morning, I said the Commonwealth may not have known that it was on a 30-day loop. What I meant was actually the prosecutors sitting in this courtroom. The three, my brothers and sister, may not have known about that 30-day override. I don't know. I don't know what they knew or didn't know. I'm certainly not going to cast aspersions and put that on them. But someone from the Commonwealth darn sure knew that was on a 30-day loop or a 30-day override. So who's had those for all this time? How were they stored? Why wasn't that information revealed to our expert when we went all the way to Canton to try to download that DVR? Where's the original? Where are the copies? These are questions for which we need some facts. And the fact that those have been withheld from us is exactly the kind of bad act and bad faith that demands that the court presume prejudice in the case. A few minutes ago, the court asked me before lunch, what is the prejudice? There's plenty of actual prejudice, but I'll get to that in just a second when I speak a little bit about the law at the end of my comments. We don't need to prove actual prejudice because the law presumes prejudice against Ms. Reed because of the bad conduct on behalf of the Commonwealth. And yet again, when it comes to this same issue, the Commonwealth recites this now worn out sentence, the prosecutor was unaware of the existence of these videos, end quote. How many times are they going to try to excuse away a blatant discovery and or Brady violation with the sentence that the prosecutor was unaware? It just doesn't matter. And that brings us to the October 10 videos that we got in 2024. The Commonwealth claims that they received these videos on or about August 21st, 2024. They sort of vaguely claim that these videos were provided along with a letter, quote unquote, letter from Canton Police Chief, end quote. There's no report, there's no email, there's no communications, there's no text message, nothing other than this, quote, letter. And it actually wasn't a letter, it was more of an informal note written on a personal pad, a Canton PD pad by the chief. There's no chain of custody log authenticating the videos, no authentication documents whatsoever, no foundational documents, no indication of where the videos came from or how she came to possess them at the time. But she did write on that little pad, quote, that is how it records, LOL, no tampering, end quote. LOL, laugh out loud. So the chief of police is laughing in the face of serious Brady violations, in the face of serious evidentiary violations and discovery violations.
And what was the date? 10/10/24 you received that? Was that the date?
10/10/24. That's correct. By the way, the Commonwealth claimed in its opposition papers that, quote, the prosecutor requested that both Massachusetts State Police and Canton Police Department produce all relevant and material surveillance video, end quote. And that was sometime unidentified between April 17th, 2024 and April 24th, 2024. I laud them for that. Good. I'm glad they demanded finally, in the middle of trial, quote, all relevant and material surveillance video. So why didn't we get this from Canton PD until October 2024, well after trial? What was the delay? And why did we get another video in January of 2025? What was the delay? How could this be seen as anything other than intentional? We know now that Sergeant Buchanan, we know that Proctor, we know that Chief Rafferty, and now through another report, we know that this officer, DGM Petro, all had access to and knew about the videos. And then we have, on top of that, in the middle of trial, I think it was Mr. Lally, it may have been Ms. McLaughlin, someone said, it's unclear from the opposition, that all relevant and material surveillance video be turned over immediately, and it still wasn't done. That is an intentional withholding of evidence. And then we get these new reports. What's probably most troubling is what's in the reports that we got on Friday, this past Friday. Additional reports from the Commonwealth in a report from Sergeant DGM Petro. He reveals the following. He writes this report on the 27th, which was last Thursday, and then we got the report on the 28th. He says that in February of 2022, and I'm paraphrasing, in February of 2022, Proctor requested sallyport video of SUV inside sallyport. Apparently that was provided. I mean, we have to presume from his report when he says Proctor requested in February of 2022 sallyport video of the SUV exterior footage that he downloaded it from somewhere and gave it to him. Assuming it was February of 2022, that would have been before the override, I presume. Because I think the math in my head is it's 28 days in February. If it's in February at all, it's within the 30 days from January 29th. So it has to have been. Then he writes that in June of 2023, Proctor requested sallyport video again. of the SUV exterior footage. Quote, this is from his report, "I believe this may also have been the approximate time that I downloaded video recordings that covered the entire time frame that the suspect's vehicle was held at the Canton police station," end quote. He goes on to say, quote, "Due to the large size of the files at that time, I had to break it down into 6-hour blocks for ease of exporting." This is the first we're hearing of any of this last Thursday. How is that?
This little comes in with a
Sure.
hot document.
Ms.
drop.
Little just handed me a clean copy of the DGM Petro report. I would like to have this marked and appended to our motion to dismiss if it's okay.
Sure. Did I get that attached to your motion to change the scheduling?
You,
You
yes.
probably did.
So I've seen it.
Okay. May I approach?
Hold on. What, Ms. Little?
We'd still like to make it part of the record if that's
Sure.
all right, Your Honor.
Sure. I just wanted to know whether I needed a copy because I have a copy. I've seen it.
May I approach?
Yes.
He drops it on his desk anyway. It's fun.
So are we marking it? So we need it if we're marking it.
Oh, I'm sorry. My mistake.
This little's doing great.
Okay. Go ahead, Mr. Jackson.
Thank you, Your Honor. The question is, how in June of 2023, now I'm going to go a little bit slow here just because
Boggles the mind.
it's linear. The argument is linear. In June of 2023, according to DGM Petro, he downloaded every single bit of video of that car while in the Sallyport or while at Canton PD in Sallyport. How is that possible? How could that be? As of February 28th or maybe March 1st, those videos are gone. So how could he have access to the whole thing? It's because someone at the Commonwealth downloaded the whole thing. They saved it. Or the only other explanation is that DVR was not at the time on a 30-day override. It's the only two explanations. Again, this is binary.
It's a good point.
So in April of 2024, as the court knows, we got additional video, and that's the inverted video. In the spring of 2024, while trial was being held, DGM Petro, quote, it says, quote, "I downloaded some video recordings that you and I believed may be needed to refute claims being made by the defense." The "you and I" is him to Chief Rafferty. That's who this report is to. And it includes footage of Higgins. So now we find out, for the first time, that Chief Rafferty and this sergeant had been talking and strategizing about how to defeat some defense arguments, presumably, by use of videos that had never been turned over. And the Commonwealth uses a phrase in its moving papers, I believe in this motion, about ambush. That is the definition of an ambush. So DGM Petro admits that he, Rafferty, and the Canton Police Department had Sallyport video that was material to the case. Remember, his quote was that "you and I believed may be needed to refute claims made by the defense." They were strategizing about how to defeat certain of our arguments, and they didn't turn it over. Specifically, he downloaded video and presumably gave it to Chief Rafferty. But then the interesting thing is Chief Rafferty held on to it. She never turned it over. Probably because they didn't help the prosecution. They showed Higgins engaged in conduct that is, at the very least, highly suspicious and clearly exculpatory because it impeaches his other testimony. It shows him on the phone when he testified that he didn't make calls in the middle of the night. There's no question that with this example, that is an intentional withholding of evidence. That is the legal definition of bad faith, and it's unconscionable to do that. Now put in context what we eventually did receive during the trial and then after. We received the inverted video that was falsely presented as the right passenger side of the vehicle, or the passenger rear side of the vehicle. Number two, we received several videos of Brian Higgins at Canton Police Department, clearly using his phone at approximately 1:35 or so a.m. And we received exterior footage that would ordinarily show the condition of the passenger taillight, which all happens to be corrupted, like every other video of the rear passenger side of that SUV. This is stunning. It's not like the Canton Police Department and the Massachusetts State Police were sort of blissfully incompetent or blissfully ignorant and unaware of the existence of these exculpatory videos. It's quite the opposite. Multiple officers, Proctor, Rafferty, Buchnick, O'Rourke, DG and Petro, these individuals, we believe, O'Rourke may not have known, but we know that the others did, and have now basically admitted it or been caught trying to hide it. They were all variously actively engaged with these videos. They were searched for, they were discussed, they downloaded them, they saved them, they copied them, they labeled them, they transported them, they reviewed them, and they strategized about them. These videos were top of mind for all of these folks. We know there were hours and hours and hours of footage that was so large it had to be broken down into 6-hour blocks. All of that was pulled. And none of this footage was disclosed to the defense before April of 2024. And most of the files that have been turned over so far have been turned over after the trial was over. We had no idea this footage existed, and to this day it continues to be, the bulk of it continues to be withheld from the defense. And then we move to Sergeant Buchnick's actual report. As I indicated, he wrote a report last Friday as well, dated the 28th. Quote, in furtherance of the John O'Keefe Canton homicide investigation, sometime in early spring of 2022, I was made aware that a request had been made by Trooper Proctor and then fulfilled by Canton PD for surveillance video as it related to the arrival and storage of the Lexus SUV belonging to Karen Reed. This was the spring of 2022. He knew. At Trooper Proctor's request, I proceeded to Canton Police and picked up the digital media storage containing said video and transported it to the Canton, Norfolk District Attorney's Office and turned it over to Trooper Proctor. I did not review this video at this time.
What date did he do that? The same date?
He says at this time, but it's the sometime early spring of 2022. That's the best he can do in his report. Paragraph 2. In July of 2023, so this is a little more defined, I was once again made aware by Trooper Proctor that a request had been made to Canton PD for additional video and that it was ready to be picked up. Since the Canton Police Department is conveniently located on my route of travel to work, I stopped by and picked up the CD from the front desk of the police department, which was labeled Trooper Buchanan with a yellow post-it note. I further added Canton PD 12922 and then the case number, which is, or their case number, 2022-112-33, to note to more accurately identify the item and transported it to our office, subsequently turning it over to Trooper Proctor. So there's a second CD, now in July of 2023. I did not review that video at that time. See the attached copy of the post-it note. Final paragraph. In my preparation for trial in May of 2024, I was provided with a thumb drive and the CD labeled with a post-it note on my desk. What's interesting is that the CD with the post-it note on his desk may or may not have been the same CD that he transported in July of 23 because they seem to be labeled a little differently.
So I haven't seen this report. Does he say from whom he received that?
I'll finish reading it, but I don't believe he does. No. No, it's pretty vague. It's passive voice, and it's pretty vague. I was provided a thumb drive and a CD labeled with a Post-it on my desk to review prior to testimony, so it does not say. At this time, I reviewed video made available to me, which included video footage of the Canton PD exterior sallyport. Exterior sallyport. This video was labeled with a Post-it note on a CD, and it contained a video of the interior of the sallyport, which was grainy and had a camera vantage point from the front of the sallyport. I also reviewed the Canton PD driveway footage. In review, I also viewed video of the back wall sallyport camera vantage point. I had not seen this video prior to my May date review. I later learned that this video was provided in an inverted manner. After I reviewed all the provided video, the thumb drive and the CD were returned. It doesn't say to whom they were returned.
Miss Little delivers another one.
Your Honor, if I could mark this report as well.
Sure. Do you have an extra copy for me?
I do.
I'm not going to count that as an interruption.
It does have one highlight on it. May I show it to Mr. Brennan?
Yes.
Apparently that mic needed to be moved. He said he was going to take about 45 minutes with his argument after lunch.
The two still marked?
So you do have an extra copy, Ms. Little?
I do not have an extra copy, Your Honor.
I thought Mr. Jackson just said he had an extra.
Oh, I'm sorry.
Yeah. Mr. Jackson, do you have an extra copy?
I think I might.
I've got it right here.
You got an extra copy? Is that one clean?
Not clean.
It's not clean, but it's clean enough. Do you want it?
No, that was the only copy that I've got.
May I approach, Your Honor?
Please.
This one has highlights on it. I apologize.
It's okay.
When the state starts talking and the judge interrupts them, I'm going to take away
right,
counters
go
from the
ahead.
interruption
Thank
to
you,
see
Your
what
Honor.
the
The
overall
court asked
score is.
probably the most important question
Zero
about
was
this
the best.
report, which is who was it that supplied the video or the thumb drives or the CDs to Sergeant Buchanan? Who's at the center of all these Sallyport videos? Who does he say was requesting the Sallyport videos that he was acting as the courier for in other particulars? Every one of those answers is Michael Proctor. So who do we believe most reasonably would have supplied the information to Sergeant Buchanan to review? It stands to reason it could have been Trooper Proctor. Seems to be reasonable. But I don't know because Trooper Buchanan doesn't say, but that would be another question that would be open to answer if we had an evidentiary hearing. Michael Proctor was receiving the footage directly from DG Petro, dating all the way back to February of 2022. He was the one receiving the footage directly from Buchanan, dating all the way back to the spring of 2022. Michael Proctor was receiving footage from both sources multiple times through the years. Proctor was the one who clearly had possession, custody, and control over the exculpatory footage. It was his, every bit of it. And now let's recall what he said at trial when asked about all this footage, because he was confronted about footage. And keep in mind, Your Honor, when I'm asking these questions, I know none of this. None of it. Michael Proctor lied during his testimony, but he knew that we couldn't impeach him. There was no way I could impeach him. I didn't have any of these videos to impeach him with, because we didn't have any of the evidence that had been secured concerning that Sallyport. Question. There's surveillance video from Canton Police Department's Sallyport garage that wasn't turned over, right? Answer. That video was discovered later on and then handed over. That video was discovered later on.
So where in the transcript is that?
Ms. Little's going to have that.
I can get you the page and line number, Your Honor.
My guess is Ms. Little can get it pretty quickly.
I'm guessing she
I'll provide that to you
can.
in just a moment, Your Honor.
June 10th?
It was either June 10th or June 12th, but let me double check.
While she's looking for that, Your Honor, may I
Please
proceed?
go ahead, yep.
Okay. The only thing it's important to remember from a date standpoint, we'll get the date that he actually testified to this, but from a date standpoint, the only thing that had been handed over at the time that he testified to that was a single video with 42 minutes missing and a flatbed and the flatbed driveway footage outside the sallyport that doesn't show much of anything. It's now been proven, that testimony, that video was discovered later on and then handed over, suggesting there was either only one video or all of it was discovered later and turned over. Both of the clauses in that sentence are a lie. The video wasn't discovered later. It was discovered in February, at the latest, February of 2022, just days after this incident. He asked for it, and he received it, according to Sergeant D.J. Petro. And it wasn't turned over either. None of it. But at trial, we didn't have the truth. I couldn't impeach him with this. He made sure that all the footage was delivered directly to him, starting days after this incident. And he controlled it, he hid it, and then he lied about it. That is the definition of bad faith. That is the definition of withholding exculpatory evidence. That is the definition of suppressing Brady evidence. There is no other way to define this. He fooled us, and it's egregious. Is it possible, with all this sort of years-long flurry that we've just talked about surrounding the sallyport videos, that the actual trial prosecutors were completely unaware of their existence until Proctor testified before the federal grand jury? Is that possible? I suppose it is. I want to give the prosecutors the benefit of the doubt. I do. Is it reasonable? That's another question. To believe that they just knew nothing about this. We know Proctor lied to us. Could he have lied to them? I suppose. But as the law mandates, Your Honor, it just doesn't matter. In the eyes of the law, Proctor is the prosecution, and the prosecution is Michael Proctor. And then we move to January 28th, 2025, this year. We're still getting additional videos at that time. This new camera angle, which is blurry and grainy and wobbly, it does, however, show the passenger side rear taillight as it's towed into or driven into the sallyport garage. The footage is so grainy and so blurry, however, it's so corrupted that once again, the true condition of that taillight is completely obscured. At a certain point, it begins to defy logic. And the reason I wanted to talk about each one of these videos in turn is because it absolutely defies logic that all of this footage magically cuts out, blurs out, becomes grainy, becomes obscured at the precise time that the SUV is pulled in to the sallyport. The question then becomes, what's been happening to these videos that have been in Michael Proctor's possession since that time, for the last 2.5, 3 years? And again, I've lost count how many times the Commonwealth makes the claim, quote, prosecutors had never seen this video, end quote. The entirety of the Commonwealth's defense on this issue is the indefensible, which is, it just wasn't me. Okay, fine, it may not have been you, but it was the Commonwealth. In quotation marks, capital. The Commonwealth then claims that, quote, after directing a review of all physical evidence and data files, after directing a review of all physical evidence and data files, this video was located within a paper case file of the investigators, end quote. I believe that Mr. Brennan, when he came on the case, he's the one who directed a review of all physical evidence and data files. I would have to guess. Again, I would applaud that. Should have happened years ago. What's most curious about this video, however, is that the prosecution now admits, quote, after inquiry it was learned that an investigator obtained this video from Canton Police Department in 2022, and it was placed in a physical case file, end quote. That's a direct quote from their opposition. They don't name who the investigator is. They don't indicate whose case file it was. They don't tell us where that case file had been, who had control over that case file, just a paper case file somewhere, mysteriously. Whether it was CPD or MSP, we don't know. Which investigator, we still don't know. What can we learn from this admission by the Commonwealth? That investigators did, in fact, download the Canton PD videos in 2022 before they were overwritten. That's the only way these videos could exist. We've talked about that. And what we don't know is where the rest of them went, and why we don't have them, and why we didn't have them for the first trial. The Commonwealth basically concedes that it is in direct violation of its discovery obligations not to have turned over these videos that were in their possession. But it makes the claim that it doesn't matter because, quote, the poor quality of the video makes it difficult for either party to benefit from the video, end quote. In its opposition, it sounds like more of a desperate argument than anything else that these cumulative, that these egregious errors don't justify the court taking any action because they claim, quote, there's no evidence of bad faith. I would take issue with that. But the quote goes on, there's no evidence of bad faith on behalf of the Commonwealth, nor any of its agents, particularly where the Commonwealth is equally aggrieved by the poor video quality and inability to obtain a forensically extracted copy of the surveillance video. Equally aggrieved.
Thank you very much. 10 months on the jury.
First, in that sentence, the Commonwealth admits that the defense is aggrieved. They say they're equally aggrieved, however. Aggrieved means wronged or unfairly treated or suffered harm or injustice. Merriam-Webster defines aggrieved as suffering from an infringement or a denial of legal rights. You bet we're aggrieved. But the Commonwealth can't claim that they're aggrieved when they're the ones doing the aggrieving. It doesn't work that way. The Commonwealth concedes that there's irreparable harm. They acknowledge that the forensic videos were destroyed, or at least they claim now that they're destroyed. We can never obtain the information necessary to establish the validity of any of these videos or whether and by whom they may have been manipulated, if at all. The Commonwealth can't shift the blame because the videos have literally been in their possession the entire time. It was their actions and the actions of their agents that caused this irremediable harm. Your Honor, this is, as I said, this is the definition of bad faith, and this goes back to the court's original question this morning, which is, can you describe the prejudice that Ms. Reed has suffered? And I think we've done a pretty good job of describing that throughout this argument, but the definition of bad faith means we don't have to prove actual prejudice. Prejudice is presumed under the law. If we're to believe the declarations that were submitted by ADA Lally and ADA McLaughlin and ADA Brennan, then at the very least there is no other conclusion but that Michael Proctor and other investigators intentionally secured these videos. They withheld the evidence from us, and they withheld the evidence from the prosecution team. Let's take them at their word. Even after being explicitly instructed to turn over that evidence, that is bad faith. And how many times do they have to say, we didn't know about this? It just doesn't matter. Like I said, let's take them at their word. It doesn't absolve the Commonwealth of its obligations, and it doesn't reduce the prejudice that the defense has suffered. This was a pattern engaged in by the Massachusetts State Police, by the Canton Police Department, over and over and over again. And now we know, through this new revelation, that it was intentional. The prejudice the defense has suffered is legally presumed, and it's also factually proven. And thus the only remedy is dismissal. When is dismissal warranted? And this is, I'd like to talk for just a couple of seconds about the legal standards. Where there's misconduct that's so egregious, deliberate, and intentional, prejudice is to be presumed. That means that the defense is not required to show Ms. Reed suffered any actual prejudice because dismissal is necessary to prevent the repetition of this type of misconduct. And that comes to us directly from Bridgman versus District Attorney for Suffolk District at 476 Mass 298. It's a 2017 case. Even if the court does not, and this is secondary to that, even if the court does not presume the prejudice and find that these myriad violations were somehow inadvertent or a mistake, the result of some accident or negligence, this case still has to be dismissed under the second scenario and the second prong, because Ms. Reed has suffered actual prejudice by the Commonwealth's violations. We could not cross-examine these witnesses the way they should have been cross-examined at the first trial. The repeated and flagrant discovery violations were not an accident. I think we've established that at this point. They weren't a mistake. There were too many people looking at them, strategizing about them, to then say, I didn't realize their import. They were designed specifically, the fact that we weren't provided the evidence was designed specifically to obtain a strategic advantage over the defense and to get a conviction at all costs rather than to pursue the truth. There are obviously additional Brady violations and prejudices that Ms. Reed has suffered. I've detailed those in our moving papers. And I want to incorporate all of those arguments by reference here as well. But relating to the surveillance footage itself, there's no question that the Commonwealth intentionally withheld it, and they've been withholding it since January 29th, 2022. The Commonwealth can't really seriously claim, Your Honor, that 4 or 5 or however many different law enforcement officers were aware of and withheld the surveillance video or the surveillance footage, and who were supposedly specifically instructed by Adam Lally or his team back in April of 2024 to turn everything over, and it was just inadvertently withheld. This was intentional. And the Commonwealth then compounded those violations by Michael Proctor lying on the stand about his knowledge of the video footage and his turning it over to the defense. It was literally a fraud on the jury. And now, well after trial, the Commonwealth has been forced to admit that even more exculpatory evidence or surveillance evidence from January 2022 is in their possession, and it was also entirely withheld from the defense throughout this litigation and throughout the first trial. In addition to the presumptive prejudice, Your Honor, there has been actual prejudice. This was, some would say, a close case when it ended. The court recalls that. The jury was hung on some charge or charges, and the evidence suggests that they voted in her favor on others. The court needs to ask itself, what would the jury have done had they had all the evidence to which they were entitled, to which we were entitled? But they didn't. Every one of these videos was in some way compromised, even the videos that we did have. And the compromise always conveniently obscured the truth and obscured Ms. Reed's rights. This is an exculpatory fact that we should have been able to explore during the past 3 years, and certainly we should have been able to explore it at trial, but we did not have the videos. The Commonwealth did, though. And it's the cumulative effect of all these gross and repeated violations that undermines the Commonwealth's argument that this is just about a broken camera. It couldn't be further from the truth. We're to believe that all these cameras just spontaneously became defective at the exact same time. Like I said before, it defies logic. For the Commonwealth to have all this footage for a solid 3 years and hold it back from us the entire time, it makes one question what was going on with that evidence. And I have to say, in terms of lesser remedies, Your Honor, what's interesting is that the exclusion, obviously the exclusionary rule exists.
I understand that does not help the defense.
It doesn't help the defense. And I appreciate the court finishing my thought on that. It's the opposite. The only remedy that can prevent this kind of repetition, this kind of misconduct, is dismissal. That's the only remedy available. And that's what the law, and that's what justice demands. As a final thought, if the court, even in the face of all this overwhelming evidence of gross misconduct, declines to dismiss this case at this time, we would urge the court to grant us an evidentiary hearing so that we can make an actual factual record of the myriad of issues brought up here. This will give the court a much better understanding of the facts supporting dismissal, and it'll perfect the record on these critical constitutional issues. And with that, I'll submit.
Okay, so thank you. I have a question for you. So go back to the podium, please, because you may need your notes. But Ms. Little, did you find the proctor testimony?
I did, Your Honor. It's June 12th, 2025, the reporter's transcript at 1-148. And that's from the copy of transcripts with sidebars, just for the court's reference, lines 8 through 12.
Great.
Thank you.
All right, I have a question, Mr. Jackson, just about, so you argued, obviously, the importance of the Lexus arriving at the Canton Police Department. You argued a distinction between a cracked taillight versus a shattered taillight.
Correct.
In your pleadings, and again, you just saw, I want specifics where I can find something. On page 28, you talked at the top line, cracked, not shattered, when it arrived at the conflicted CPD on January 29, 2022. If the taillight was largely intact and only cracked, rather than shattered and missing 47 pieces, as Dayton Police Officer Sergeant Barrows testified he observed earlier that day, after the Commonwealth claimed Ms. Reed had struck Mr. O'Keefe, the evidence would establish Ms. Reed's innocence and be case ending for the Commonwealth. The 47 pieces I'm having trouble finding. I just took a quick review of Sergeant Barrows' testimony yesterday upon being prepared for this. I didn't see it in there. Ms. Little, do you know where that 47 pieces is?
Yeah, the 47 pieces is not related to Sergeant Barrows' testimony.
Well, it sounds it from this, so I'm not to read it this way.
What Sergeant Barrows clearly testified to was that he observed a taillight that was cracked and not broken.
Okay, the 47 pieces, I read that to mean it was from Barrows' testimony.
No.
As Dayton Police, Barrows testified. All right, where do I find that 47 pieces?
The 47 pieces, I can get multiple transcript sites, but those were the photographs the Commonwealth presented at trial, that there were that many pieces found at the crime scene.
It's the number of pieces that were booked into evidence.
Okay.
Yeah.
Great. Yeah, if you have trial transcript of that, I don't need 47 points, but if there's something that summarizes it. Because I took that to read as I see it reading.
No, Sergeant Barrows specifically testified about his observations of the taillight earlier that day.
Right.
It was uncontroverted that there were 47 pieces of taillight recovered at the
That's not clear to me the way this is written, so I'm glad I asked you. Okay. All right, so with that, now, Ms. Tinetti, I'm not going to hear from you now about the court officers not being in charge of the jury. I'm going to hear from Mr. Brennan, and then we'll get to you, and hopefully we'll have time. But Mr. Brennan, I have a question for you. As I started with a question for the defense, so I'd like you to explain.
My question is just WTF.
To the court, please, what efforts the Commonwealth made to comply with the Rule 14 obligation regarding the sallyport videos, and why the dribs and drabs of the way the discovery came in.
It may be most helpful if I give the court a history as I've learned it about the production of video in this case.
Okay.
And it will explain in context the production of video and will help create the foundation so the court can understand and perhaps the defense can best understand.
All right, and just like I did with Mr. Jackson, if I need to, I'm going to interrupt you to clarify some of this.
And
so know that that's what I'm focused on.
I understand clearly. In November of 2024, the defense asked me to see if I could provide a chain of custody regarding the production of video in this case. And so I agreed that I would do that and made best efforts to talk to as many witnesses as I could, review the discovery, and speak to the attorneys. Now, when I started sometime in late September, I had found the letter from Chief Rafferty with the production of video in August. The letter or note was dated in August. So to start from the beginning, the prosecutors in this case did not have knowledge that there was videos from the sallyport area. There was nothing about it that was particularly relevant to them. The defense theory did not
relevant to them?
Make it clear to them that that was important. There was no motion filed by the defense.
At what point in time?
This is leading up to trial.
Okay.
At that point, there had been no request by the defense for video of the sallyport area. What I learned is that Trooper Proctor had requested sallyport video from the Canton Police Department. And the person who was the custodian of Canton Police video who would download it from the DVR was Sergeant D.G.M. Petro. He made a request shortly after this event on January 29, 2022. Sergeant D.G.M. Petro downloaded video from the front wall camera, which was later characterized as the blurry camera, and he left it at the front desk. Trooper Buchanan, at the direction of Trooper Proctor, picked up the video and he brought it to Trooper Proctor. Trooper Buchanan did not look at the video at that time. It was given to Trooper Proctor. Trooper Proctor did not provide it to the prosecutors. So Trooper Proctor was aware of the video. The prosecutors were not aware of the video. That video is the same video that Sergeant D.G.M. Petro says that he downloaded the video in 6-hour segments, and that contained the front wall blurry camera inside the sallyport and camera in front of the police station. That remained with Trooper Proctor for some time. In June, around June of 2023, Trooper Proctor then made a second request from Sergeant D.G.M. Petro.
Even though he already had it?
For different cameras. He wanted cameras, camera angle of outside the sallyport area, so when the tow truck dropped the car off, leading into the sallyport, which is now characterized as the exterior sallyport video. Again, Trooper Proctor asked Trooper Buchanan to go to the Canton Police Department and pick up a copy of the downloaded video. Trooper Buchanan went to the police department, picked up the CD at the front desk. That CD had a yellow sticky tab on it with Trooper Buchanan's name, and Trooper Buchanan wrote in the case file on that yellow sticky. He brought the CD to Trooper Proctor. Again, Trooper Proctor in June 2023 had a copy of the exterior sallyport video, but did not provide it to the prosecutors. Both of those videos remained dormant. When Trooper Proctor was called to the federal grand jury, essentially he testified or was asked about video and said that he reviewed video. Now, this was not evidence that the Commonwealth intended on introducing or had any specific interest in. There was no particular discovery request by the defense, and there was no order. But upon reading that grand jury testimony, ADA Lally reports that he then inquired about the video. This is
Inquired of whom?
Trooper Proctor.
Okay.
This is shortly before trial. ADA Lally was given a copy of one of two of those productions. He was given the copy of the front wall video, which also contained video of outside the front of the police station. That was quickly turned over after Attorney Lally received it on April 4th, 2022. So what we know at this point is Trooper Proctor has this original production on April 4th, 2022, shortly after January 29, 2022. I'm sorry, it was provided April 4th, 2022.
2022 or later?
No.
It was later, right?
It was
because
later.
the federal grand jury was later.
He provided it on the eve of trial. So it was April 4th, 2024. So we know this production on April 4th, 2024 was in the hands of Trooper Proctor shortly after January 29th, 2022. At this point, the prosecution team is still unaware of the June 23 production, which has Trooper Buchanan's name on it, which shows the exterior sallyport. As trial began, there still was no specific order or request. The chief of police saw something about the trial, and let me rephrase.
Yeah.
Prior to the trial, it's reported that Attorney Yannetti was discontent because the video of the front camera sallyport was so grainy, intermittent, and not continuous. And that's an accurate description of that video. Chief Rafferty, in response to seeing Attorney Iannetti's concerns, then asked Sergeant D. Giampetro to see if there was another camera or to produce any other video from the Sallyport. Sergeant D. Giampetro then downloaded video from the DVR, which is the second camera that is inside the Sallyport, known as the inverted camera, or now characterized as the inverted camera.
Copied over?
That was produced April 23rd, 2024, given to ADA Lally, then given to the defense.
What?
And so at that point, there are 3 video productions that exist. The first turned over to the defense April 4th, 2024, the second April 23rd, 2024, and the June 23 production of the exterior Sallyport has still not been turned over. It's in the possession of Trooper Proctor, and the prosecutors do not know about it. After the trial, one of the employees from Norfolk County, Colleen Crawford, went to the Sallyport and looked at the DVR system. And when she looked at it, she saw that video still existed on that system. Although there was a 30-day overwrite on that system, the system had a number of backup hard drives, and because of the backup hard drives, the video existed longer than 30 days. She wrote an extensive report that was turned over to the defense, and this is after trial. The report notes her investigation about all the different videos, and it summarizes everything that she saw in that July 2024 visit. As I mentioned earlier, in August, Chief Rafferty provided video of the hallways that included some video of Brian Higgins, and she accompanied a letter or a note. I learned that that video was copied during the trial, and it is noted in the sergeant's letter. The chief of police and the sergeant were downloading video not in response to a motion to compel or produce, but rather because they had concerns about accusations that were being made about the department, and they were saving video, in their opinion or from their perspective, to help defend against future false claims against them. They downloaded a number of videos that were then turned over in that August 2024 production. When I first learned of that August letter and note, I turned it over to the defense immediately. The issue came up regarding the DVR in November, and as we've litigated extensively, so I'll simply summarize it, I invited the defense to come to the Canton Police Department. Given the intermittent or spotty production of video, I thought it best they have an opportunity to look firsthand, although I didn't know if the video would exist, as I've said. And then when they came in December, I think it was December 12th, if my memory serves, and learned that there was no longer video stored because it had been overwritten, I then went to the Canton Police Department so that I could have a closer look at the video cameras to see if there was something missing. I toured the entire station, I learned about the videos, and then as a consequence, I spoke to the chief, other officers, and the sergeant. Unexpectedly, the sergeant told me that he would click and drag copies of video when he would download them from the DVR.
So he'd delete it from the source?
Inevitably, we had the litigation about whether the defense was going to download in person or not. And then as I tried to finalize my investigation into the tapes and realizing there was no actual written chain of custody, I wanted best to memorialize it. I had been reviewing all files, data, hard files, but I had not been on the case long enough to review everything, so I asked that the parties of the Commonwealth look through all files, all databases, so that I could help facilitate my review. At that point, I was provided by Trooper Tully the June 2023 CD with Trooper Buchanan's name on it. That is the exterior Sallyport video. And within 24 hours, I provided that to the defense. I then asked both the sergeant and Trooper Tully and Trooper Buchanan to write reports. Since there was no chain of custody, I wanted best to give as much information as I could and document the history of the video. That, Your Honor, is a summary of everything that I had learned, the investigation, and the production of the videos.
Do you know which investigator's file it was found in?
Trooper Proctor's.
Ooh. Proctor has been formally thrown under the bus.
Okay.
Your Honor, I have 3 separate arguments. I will proceed with the videotape argument since we've lodged into it.
Sure.
Okay. Now, the defense has made a number of conclusions that there was somehow videotape that was tampered with. There is absolutely no evidence whatsoever, none. It's not even speculation. There was no evidence that any videotape was ever tampered with. They say it, but there's none. I have seen none. They have produced absolutely no evidence that any video was altered or tampered. The defense lodges the idea of bad faith, that there was some type of advantage in that this video was withheld from them on purpose, and again, that is a baseless claim. If the government was going to hide video from the defense, they never would have got it. Maybe they would have got something after I came in and looked. They would have not got this production in April 2024. They would not have gotten the production if the government was looking to hide anything. And so the idea of intentionally withholding or bad faith is just characterization by the defense.
If we would have hidden it, we would have done better. They never would have gotten it.
Now, first, Brady needs to be exculpatory, and that's going to be something I think I can demonstrate does not fit this case. And secondly, in order to compel the court to conclude there was some type of remedy that should be issued, they want the court to conclude, like they do, that there was some type of tampering or some type of destruction of evidence. There was none. There was none. Now, Trooper Proctor had this video from June 2023 in his file. And I think the best evidence that this was not intentional is if you review Trooper Proctor's trial testimony.
So do you have a volume? Is it at the same place that Ms. Little gave me?
Well, I have the same volume. They gave you a fragment of his testimony, which is about 3 sentences, but if you actually read a number of pages of his testimony that deals with this video, and it begins on page 133, what you will see, and I won't spend a half hour reading it, but what you will see is that Trooper Proctor was aware of the grainy video, which was the video that was provided right after January 29, 2022. He was unaware of the inverted video until it was produced right before trial or right during trial by the Canton Police. And you can also see that he in no way was hiding the June 2023 video, because you can see the confusion between all the parties at trial. Attorney Jackson is asking Trooper Proctor about video, and Trooper Proctor is explaining there is a sallyport video, and also there's an exterior video outside the sallyport. And it is clear that Attorney Jackson does not have that June 23 exterior sallyport video because he's very confused in the questioning of Trooper Proctor. And Trooper Proctor continually tries to explain that there is both the sallyport and there's the exterior video. So clearly Trooper Proctor was aware of the exterior sallyport video, but it will be clear from the reading of his cross-examination that there was no intentional withholding. He should have, since it was in his possession, whether it was relevant to the government's case or not. He should have provided it to the prosecutor, and then it would have been properly provided.
There's the rub.
But it was his oversight. There was nothing intentional or advantageous about it, because he struggled to try to explain to Attorney Jackson. And so it's also notable that Attorney Lally never has an opportunity to ask more details about those. Well, he has the opportunity, but he doesn't ask more details about that misunderstanding because he's wholly unaware that it even exists. It's a confusing moment, but it clarifies that there's nothing intentional whatsoever about this course. And so it's important that although the defense now suggests there's something exculpatory about it or something about it that's important, it is important to note that the defense never filed a motion for the production of the Canton Police Department video. It is not incumbent or assumed that the Commonwealth is going to obtain every video from every part of a town during an incident. It's not assumed that they will do that. The Commonwealth seeks evidence that they think is exculpatory, they seek evidence that they think is relevant and material, and when they receive it, they are supposed to provide it. There are many cases where video from a police department is never provided to the defendant unless they ask. Or many cases where it may be a video of the booking, but not the hallways, not the bathrooms, not the back parking lot. Put in context that the defense theory was an evolving theory throughout this case to this day. The defense theory was that it was some third-party culprit, unidentified, who committed this act that led to the death of John O'Keefe. In fact, if you see earlier interviews, the defense position publicly was, you know exactly who did it, intimating that it was a specific person. Now that recently has changed. If we see the recent interview 2 weeks ago on Fox 25, the quick answer was, we have no idea who did it. We don't have to know. And so this fluid position is not notice to put the Commonwealth on notice. They're supposed to chase down every potential idea or creation that the defense has. It's important to look at the motion that has been presented to Your Honor on behalf of the defense where they claim that they moved to preserve video evidence. And when you look at that motion, the best it says is that they moved to compel physical evidence. That does not put the Commonwealth on notice of video evidence at the Canton Police Department.
Was this the Stoughton District Court motion?
It is.
Okay.
And I know that the Superior Court did not adopt it. However, I think the Commonwealth being on notice is the point. Even if it's in district court, I think it's the Commonwealth's responsibility.
I agree with that.
Okay. And so, Attorney Yannetti, and I've mentioned this before, was very prolific in his pretrial discovery motions. Very meticulous. And when you look at his meticulousness, if there was a need or a desire for video, he certainly would have asked for it. He didn't. In fact, when you look at the perspective of Attorney Yannetti, you don't have to look much further than his characterizations of how he sees the difference between the crime scene and the Canton Police Department. I've attached, for Your Honor and for the defense, exhibit number 4, trial testimony of Trooper Nicholas Garino. And when he cross-examines Nicholas Garino, he is pretty clear that there is a difference between the Canton Police Department and the crime scene. He cites on page 75, but you'd agree with me, the Canton Police Department wasn't the crime scene, correct? And Trooper Garino says, I never said crime scene in my report, I wrote scene. And Mr. Attorney Yannetti iterates, okay, well, Canton Police Department was not the scene of any crime, was it? So the defense is hard-pressed now at this moment where they are trying to create prejudice that doesn't exist, to try to convert a motion that they filed with very specific intentions for physical evidence to now suggest that includes Canton Police Department because the Canton Police Department is somehow the crime scene. It doesn't convert. In argument, Attorney Jackson characterizes not only Trooper Proctor's testimony, and I encourage the court to look at that because when you read it in context, I think it clearly screams that Trooper Proctor is hiding nothing whatsoever. But if you look at Trooper Buchanan's testimony, on June 6, 2024, if you start at page 103, Attorney Jackson, and to paraphrase, I'm not quoting him verbatim, suggests that there's something about Trooper Buchanan that is lying about his position or about what he saw, or that Trooper Buchanan admittedly saw the inverted video. Not the case. Trooper Buchanan reported that he did not see the inverted video until after Canton produced it, because how would he see it before Canton produced it? And that was in his preparation in May. And he did not say that he sat down with ADA Lally and watched the inverted video. He was asked, were you shown any of the videos that you see in anticipation of your testimony? Now remember, there's not just Canton Police Department video at that point. There is video from Ring, Town Hall, a number of different places. And he said, not during the first meeting. I did review video during the second time. Question, okay. And that video that you did see the second time, was that the interior video of the sallyport that we saw yesterday, correct? He says, Trooper Buchanan, I'm just trying to remember exactly what video I saw. I had reviewed videos outside of our meetings. That is what he put in his report about reviewing in May, not with ADA Lally. So I don't remember exactly what video Mr. Lally showed me. That wasn't the characterization that was provided in argument. This is very different. Question, but you do recall seeing the video that you saw yesterday, the sort of clear one that has the crime scene tape being put up and all that. You've seen that one before. That's the inverted video. Answer, yes. I'm on page 104. And that was with Mr. Lally, correct? Trooper Buchanan, clearly. That is not correct because I do not recall when I saw that video or what video I saw with Mr. Lally. That sworn testimony is not only in stark contrast with the characterization that was offered by the defense, but it directly contradicts the conclusion they asked you to reach, that Trooper Buchanan watched this video with ADA Lally in preparation for trial. Therefore, it is a lie that the Canton Police Department provided the inverted video sometime earlier. That's sworn testimony. Now, again, trying to assert some type of relevance, the defense suggests there is something in the federal materials that would show relevance because Mr. Higgins said in the federal materials that he does not believe he made any phone calls. If you were to look at that testimony in the federal materials, you would see there was an enormous amount of conversation about the period in which he was sleeping. And there were dialed calls between him and Mr. Albert. And so you have to look at it in context.
There were butt dial
rather
calls.
than say it's an unequivocal denial and there's an aha moment. There is no aha moment. So,
do you have the grand jury cite? I think I might have got it from Ms. Little earlier, but the grand jury testimony of Brian Higgins. I have it. It's just easier if you have a cite to that.
I have a tab, but I don't. Perhaps Attorney
I'm sure Ms.
does.
McLaughlin can get it from.
I'll provide it momentarily.
All right, thank you.
Ms. McLaughlin.
So,
good job.
What really arises from the subterfuge is that the defense did not ask for video. There was video provided when the prosecutors learned about it. There was video that was in the hands of Trooper Proctor that should have been provided to the prosecutor that wasn't. There was nothing done to alter or taint the video. There was nothing destructive about it. There was no tactical advantage. There was no benefit to the government. And clearly from Trooper Proctor's testimony, there was no effort whatsoever to hide it. It should have been managed better, no doubt. But there was nothing about it that was prejudicial. There was nothing about it that showed tampering or altering. And so ultimately, the import of the defense's argument is that this evidence, this information, is exculpatory. It's exculpatory because what they claim is that it would show that Miss Reed's taillight was cracked, not missing a piece. Now, first thing we look at is Nick Barrows' testimony. And if you have an opportunity to look at his testimony, on page 12, line 1, the defendant told you part of the story. I saw there was some damage to the rear taillight. To my best ability and recollection, that taillight was not completely damaged, it was cracked. But they forgot the next part. And there, pause, a piece missing, but not completely damaged. That's exactly how we see Miss Reed's car later on, after it is at Canton. The entire taillight is not missing. There is a piece missing. That piece, where the fractures of it are found at 34 Fairview, right near Mr. O'Keefe's body. The same parts of the taillight fragments that are found in the sleeve of his shirt. And so it's not simply cracked. Even the witness they tried to lean on, Mr. Barrows, says more. And so if that taillight is not just cracked, if that taillight is missing, then there is nothing exculpatory whatsoever about the Canton video. It's a red herring. Because there can be no plant of fractured taillight if it's already gone before it gets to Canton. There can't be. And so when looking at the evidence, it is unequivocally clear that piece of the taillight is missing well before that car ever gets to Canton. And so we can quibble and we can dispute and we can go back and forth all day, but the best way is to just show you the evidence. And so when we look at the evidence, let's start first with the claim that the sallyport videos were tampered with. Canton went back before January 29, 2022, and they took samples of the video to see if it was in the same condition, inverted for the back wall and fuzzy for the front wall. And we have those, and we've turned those over to the defense, and I just want Your Honor to see a small clip of that to show this condition, these conditions existed before this case was even a moment. So with the court's permission, I'm going to ask to put up exhibit number 2. Exhibit number 2 shows the inverted camera from January 1st, 2022. Now this is 28 days before Ms. Reed's Lexus hits the sallyport area. Now you can see, if you stop that please, thank you very much, on that wall, on that garage wall, there's a 4, it is backwards. This sallyport video was not doctored by Trooper Proctor. It wasn't altered by Trooper Buchanan. It was in existence well before Miss Reed's car showed up to that sallyport. Similarly, front wall camera, could you please put on exhibit 3?
Who added that yellow description on the bottom?
Exhibit 3 is from January 28, 2022, a day before Miss Reed's vehicle makes it to the sallyport. And you can see the quality. It wasn't distorted on purpose. It wasn't manipulation by the state police. This is the way the camera worked in
Somebody
Canton.
have bubblegum?
Thank you very much. And so the idea of tampering, we can claim it, we can assert it without fact, but we can prove it did not happen. Now, what we know is that missing taillight was not tampered with because it was gone hours before police even touched Miss Reed's vehicle. At 5:08 a.m., she left Meadows Road. That's John O'Keefe's home. And when she left at 5:08 a.m., that taillight part was already missing. If we look at exhibit 6, please. This is from the ring video of John O'Keefe's home. This evidence directly contradicts the idea that the sallyport video is relevant to show any break or planting of evidence.
Was it snowing that night? Does anybody
As
know?
Ms. Lee nudges into Mr. O'Keefe's car, she will pull forward and we'll stop the video in two spots so you can get a clear look of that rear tail light missing. Forward, please. Thank you. And then ahead one more. You can see the white light shine. Stop. You can see it clearly missing. You can't plant something that's already gone. And the reason why you see white, it is a red taillight cover, and when the red is missing or gone, as it is in this case, the white bulb still shines, and that's why it shines white. The defense position is also contradicted by the ARCA witnesses. If we look at Dr. Wolf's testimony, day 31 of trial, it's noted as Exhibit 10 in our package, page 36. ADA Lally asks the good doctor, now doctor, in the course of your analysis or review of materials here, were you ever provided with a video of the defendant backing out a garage and making contact with Mr. O'Keefe's vehicle in his driveway at about 5:07 in the morning on January 29th? He says, I'm not aware of that. And then if we move to page 124, line 1. Now, line 2. Now, as far as you're aware from the review and your testing and everything that you did in this case, if a collision occurred at a lower speed, say 1, 2, anywhere from 0 to 5 miles an hour, would that create the damage to the taillight that you observed in this particular case? And Dr. Wolf says, at that speed, no. We provided notice of our own expert. And there's one thing, many things, but one critical thing the experts will all agree on. That nudging did not cause the damage to that taillight. The defense position is also contradicted by dash cam footage. Sadly, an officer went to the O'Keefe home to check on his niece and nephew on that tragic day. And when he did, he had a dash cam video further reinforcing that that taillight is missing well before that vehicle makes it to the Sallyport area. If we could play Exhibit 7, which is the dash cam footage showing Mr. O'Keefe's car in his driveway at 8:22 a.m. If you could close up for the court, please. If you compare the right side to the left side, although covered and impacted by snow, if you could more close up, please, you can see that taillight, just like the detective from Dighton said, just like the 508 ring video shows, is missing. Is missing. There's no plant. The defense's position is also contradicted by the alarm.com video that we received pursuant to Rule 17. There are two videos, 8 and 9. If we could play Exhibit 8, please. This is the defendant's car arriving in Dighton in the driveway. The defendant on the passenger side, and you can see them walk to the back of the car near the right taillight and stop. And if the question is, what are they stopping for, we can play video 9. And this is when the car is being put on the tow truck before it makes it to Canton. And just like 508 in the driveway of Meadows, John O'Keefe's home, you will see that right taillight shine white, showing the missing taillight cover on 2 occasions. If you have an opportunity to stop the video at the important points, please do so.
Can you lower it?
We cannot. Can you aim the camera higher, says the judge.
Can you zoom in on it?
Your Honor, I would encourage the parties to look at it on the computer. The clarity is much better, and it's very clear, the white light missing video. I cannot see it clearly on the screen.
So will you give me a flash drive of all of these exhibits?
Oh, there we go.
Okay.
If you look at it on a small screen, see right there?
I do see it.
Yeah, and then you'll see it again. So the alarm.com video contradicts the defendant's position that there is anything exculpatory about these sallyport videos. In fact, this whole idea of third party or plant doesn't come to town until 9 months after Ms. Reed is indicted. Perhaps the best evidence that contradicts the defense's position that there's any relevance to the sallyport video, that there's any type of plant by anybody, is from the defendant herself. Ms. Reed spoke to Gretchen Voss on June 20th, 2023. And in that testimony, or in that interview, she said, when my car was seized, there was a few small pieces of taillight missing that I had picked out at John's at 5:45 before we drove over to Fairview. I'm showing Jen and Kerry, look what I just did to my light. And I'm worried that there's gonna be some kind of electric short circuit. There's like the bulb is showing and some of the red plastic is missing. So I picked pieces out of the light housing that kind of collapsed within the light and dropped them in John's driveway. And so I say to the court, the production should have been sooner. It should have been cleaner. There should have been a log or an entry. The failure to provide was inadvertent. It was unfortunate. It shouldn't happen. But it's not Brady. It's not exculpatory. It's not intentional. It's not tampered with. It was inadvertent and inconsequential because the evidence is overwhelming that that light is missing before the car makes it to the foot of the sallyport, so there can be no plan. That is my argument regarding the Rule 14 issue. I would like to have time to speak about the claim of jury tampering. I understand the temperament of the court. I'm not tone deaf. But it is a claim that was lodged that has collateral consequence. And I think it's important for me to be able to address it. May I?
Yes.
All right, let's hear it.
The claim of jury tampering is probably one of the most serious claims that one can make, because it's not simply an attack on a case. It questions the fabric of our entire judicial system. If a good juror comes to court and believes there is no integrity in the court or in the judicial system, it is impossible for a fair-minded juror to even consider evidence because they do not trust the system to begin with. And if a government actor or a trooper or a police officer tampered with a jury, that would be one of the biggest, most abhorrent transgressions that could happen. Because of the collateral consequence of tampering with the jury, it would take away the community's belief in our system. On the other hand, if there is a claim of jury tampering and it's baseless and there is no evidence, it is not only a direct attack on the judicial system, it would seem to be an effort to try to undermine the authority of the system in court before a trial to impede the ability to have a fair trial. It is an extraordinary claim. And it's notable, the defense motion to dismiss. It's not just a motion to dismiss. It's a motion to dismiss for extraordinary government misconduct. So when you make an extraordinary claim about jury tampering, there should be extraordinary evidence. There isn't even ordinary evidence. There is no evidence of jury tampering in this case. Now, I don't want to belabor this, but it's important because of the consequence of what happens when a claim like this is lodged. There is damage. And why I'd rather sit down, as I said before, a lie unchecked becomes the truth. And so, how does one propagate a claim of jury tampering when there's no evidence? Well, first you need to plant the seed of corruption. And all you have to do is whisper it and hope the poison goes out there and is resonating in the potential community. And so what happens in this case? The defense finds a willing partner who covets an opportunity to meet with the defendant. They find a time, like after the Super Bowl, so there's this national exposure, and they just seep the information. They just seep it into the public and let it resonate. There can be no retort. The government can't respond. No facts, no evidence. Just saturate the public. Now, it's important to see or hear or read what is said, because this really is the acorn that is being planted that cannot be rebutted. And it's not
squirrel can
insignificant that this same information before this interview is being disseminated by Mr. Kearney. This idea that there was tampering by Lieutenant Fanning. Not a coincidence. And so during this interview that the defendant and the attorney have, the question's asked, I don't know why it's asked, but it's asked, there have been sort of these unsubstantiated claims in the atmosphere that there might have been some funny business with the jurors who were dismissed. Really? And Mr. Jackson says, right. The question, is this a real concern that you have? Is this something that you were looking at, or have you just dismissed it as a rumor? Answer, I never just dismissed that as rumor. Something like that, it's too convenient for the prosecution for us to just dismiss out of hand. Do I have any evidence, specific evidence that there was jury tampering? I don't have any specific evidence of it. And yet we have a motion filed 2 weeks later. Do I think there are questions that should be asked? Do I think that there are questions that have been raised about the way the jurors were dismissed and who was dismissed very specifically? And then it continues on page 13 of the transcript. Question. One of the state troopers who was involved with the Norfolk DA's office and on the periphery of the investigation was also responsible for the jury? Not sure where these questions come from. Answer, right. He wasn't that far on the periphery of the investigation. He was involved in the investigation. He was direct supervisor over the individuals that were testifying and over and about whom we had leveled some very, very serious claims and ended up proving those claims during the course of direct and cross-examination in the presentation of our case. That person, that supervisor, we found out well into trial. As a matter of fact, at the end of the trial, we found out is the very person who was governing the jurors. That's a question that should be raised. That is an issue that should be teased out. Should never, ever happen. That is the very definition of a conflict of interest. Question. Is that standard in Massachusetts for just the DA's office to assign whoever they want to be sort of, supervisor of the jury? Yeah. Is it standard in Massachusetts? I hope not. Never seen that in my life. But if I had a nickel for every time I said I've never seen this type in my life as it pertains to the Massachusetts justice system, the criminal justice system, I'd have a lot of nickels.
Wooden nickels. Love them.
So I didn't see that interview. I don't have the transcript. I'd like a copy of that transcript.
Your Honor, I understand, and I may be mistaken. We produced all of the exhibits to the court, and you should have a transcript. If not, I will get it to you immediately.
Okay.
Okay. So after step one, finding a vehicle to plant the seed, and they did that very effectively, the next step is they have to identify a target. Who are they going to blame? Who's going to be the villain? In this case, a villain goes from anybody that gets in the way. It could be a soccer mom. It could be a police officer. It could be a good Samaritan. Anybody that crosses the path is a target. And now they decided they were going to identify Lieutenant Fanning. Lieutenant Fanning is one of the most conscientious, dedicated, admired state police officers in Massachusetts. After having his name attempted to be sullied all over social media.
Is that him?
Attacking his integrity and his name.
Is that him sitting with the family?
I can dare say that Lieutenant Fanning is in a different position than many. His integrity is so reputable, none of that will break him or his reputation. But it happened. When you look at the motion filed by the defense in this case, and they found their target in Lieutenant Fanning, you look at this motion, page 15. It's important when they made this public pleading, getting back to my request for your honor the other day. You look at the bottom of page 15. It talks about Lieutenant Fanning and tries to align him or associate him with Trooper Proctor because Trooper Proctor's text message was on a chain that included Lieutenant Fanning. Lieutenant Fanning did not reprimand or otherwise correct his subordinate's disgusting and inappropriate behavior. As a result, he was investigated by the Office of Professional Integrity and Accountability for allegations of inappropriate correspondence between department members. True. But then they leave off the punchline. They put this in a public document. They try to smear him, degrade, demean, dehumanize. But what they leave out is that after this thorough investigation by the Office of Professional Accountability, where they took strong measures, very strong measures when they found something that they were not in agreement with, they concluded that these complaints were not sustained.
So we were all aware of that. I received verification of that through the Pleadings Council, was all aware of that. I just need the date. When was he cleared? When was that made public?
We'll have to provide that to you.
Was it prior to this? Was it prior to the motion being filed?
Yes, it was last year, last fall. I can provide the date right now.
Okay.
Trooper Lieutenant Fanning is not in a unique position.
If I may, Your Honor. Sorry. It was July 17th, 2024.
He is similarly situated to the many first responders and witnesses in this case. And then, without any basis, the defense then distorts that Lieutenant Fanning was in charge of juror security. He had control of the jury, and he had access to the jury. Think about what those statements say to our community, who are going to pile in here in less than a month to try to give a fair trial to both sides. Think about what those words mean.
I'm thinking about what the words mean.
After selecting their target and trying to dehumanize him and degrade him, they then try to create an illusion of this grandiose havoc that is running amok. Trying to get the community to think Trooper Fanning controlled, had access, and tampered with the jury. Think about that concept. Not only is it an attack on Lieutenant Fanning, it is an attack on the integrity of the trial court. I've walked a lot of hallways in the trial courts over the past 30 years. And the heartbeat of trial courts is the court officers who take their duty so seriously. They help, they assist, they guide, and they have solemn pledges. They are charged with the responsibility of the jury. To suggest this is to suggest that the hardworking men and women in our trial court system who come here every day for everybody else's benefit, it is to suggest that they would cede their authority to the state police and abscond from their duty and responsibility to protect that jury with no basis whatsoever. That is the concept that they are promoting in this motion. The trial court personnel throughout the state are steadfast and dedicated. I've tried a lot of cases, and I think most of the lawyers in here have. It is without a doubt in Massachusetts that these dutiful men and women of the trial court protect and are sworn at the end of every case in jury instructions to protect the jury. And these trial court employees, especially here in Dedham, some of the finest, would never abscond that duty. And yet it is now in the public domain, this suggestion. The only way that you dispel innuendo, suggestiveness, unsupported claims, and the poison that can seep into the community, the only way you can stop that is with fact. So I'm going to list a few facts for the record. Fact: Lieutenant Fanning was not in charge of juror security. Fact: Lieutenant Fanning did not have control of the jury. Fact: Lieutenant Fanning did not access the jury. Fact: Lieutenant Fanning was part of a multi-agency cooperative effort to ensure the safety of the public and court participants, which required numerous local police officers and state police because of the bedlam that was created outside. Fact: Lieutenant Fanning never, ever, ever met with or interacted with any juror. Fact: at all times, Lieutenant Fanning worked from a remote location, jointly managing operations for the safety of the public. Never setting foot on this property when the jury was here. Never meeting a juror, never looking at a juror, never being seen by a juror. Fact: no evidence any trial court personnel ever ceded their obligations and duty and handed them off to Lieutenant Fanning. Fact: Lieutenant Fanning heard numerous rumors from various sources about a juror who expressed potential bias. Fact: Trooper Fanning never investigated, approached, or inquired. He heard the information and provided it to the trial court as is responsible, dutiful, and proper. And I'll repeat one more time, Lieutenant Fanning never, ever, ever interacted, controlled, or met with any juror. Your Honor, these claims in the motion to dismiss have a theme. Different issues, same theme, same pattern, same effort. Your Honor should dismiss it outright, and we should move to trial. Thank you.
All right, response.
If I may, Your Honor?
Yes.
Thank you.
Make sure you leave time for Mr. Yannetti to do his little thing as well. He's got a few pages.
We're going to address in reverse order some of the statements made by Mr. Brennan. And I want to talk first about this issue of juror interference, which is what we called it. These words matter. We've claimed that there's interference. He indicates that that would be an abhorrent transgression if there were interference with a juror or a jury. We agree. It would be an abhorrent transgression. The information that we have in front of us is not the information that Mr. Brennan just recited, which is interesting. I'll get to the facts that he very dramatically stated in just a second, because this is a fact-based inquiry, one that we asked for standing right over there at sidebar and didn't get. But Mr. Brennan, with no support to back it up, and I'm going to ask a couple of pointed questions about that, recites these facts after facts after facts that he claimed absolved the Commonwealth of any transgression as it pertains to the jurors. And when I say Commonwealth, I'm talking about the Massachusetts State Police. Very clearly, in a clever, almost too cute by half argument, Mr. Brennan talks about the good court officers that are populating this courtroom and this courthouse, about whom we have made no allegation, no claim, nothing. We have nothing but the highest respect and regard for the men and women who wear that uniform and perform these duties. None. Zero. And he knows that. But in an effort to create an enemy where there isn't one. He acts like we've insulted the court officers, which we haven't. He also said that Lieutenant Fanning stood up here and gave basically a CV, a resume for him, and said, "He's the greatest guy on the face of the earth." I don't know Lieutenant Fanning. I don't know if he knows Lieutenant Fanning. Not really the point. This isn't a personality contest. He said that we identified somebody with an unassailable reputation. We identified him. We didn't identify anybody. We were standing up at sidebar, fat, dumb, and happy, not knowing what was going to happen, when somebody else identified him. It wasn't us. And by the way, everything that we filed concerning this was under seal. We didn't disclose anything in any court document. It wasn't a public document, it was under seal.
Fat, dumb, and
Mr.
happy.
Brennan then states that he was also a subject, this person with this unassailed career, was the subject of an IA investigation for his conduct on this case. It's not even about something tangential. It's about his conduct on this case, his supervisory role as it pertains to Michael Proctor and his, and I'll repeat it, disgusting conduct as it relates to my client and his text messages, etc. When he was asked about those text messages, his claim was, I was on vacation and I didn't read them. And ultimately, the Massachusetts State Police investigation cleared the Massachusetts State Police officer. We've seen that happen before. The question, or questions, if I could, that surround this inquiry, and the reason that we included it in our motion to dismiss, is because it appears that Ms. Reed did not get a fair trial because of this juror's dismissal. How would the person who's unidentified, to this day, unidentified, how would this person know who the juror sitting in one of these seats was if she was at a private location? I won't mention the location. How would they know? How would they know to identify her? How would they know what she said? How would they know to record her illegally, potentially, if that happened? How would they know these things? How would they know that if she was a juror, that she was a juror on the Commonwealth versus Reed matter specifically? And how would this unidentified person know of all of the authority figures to go to Lieutenant Fanning, of all people, who is then described to us after the fact as the, quote, commander of the extensive security operations that this case has required. And I went through that with the court this morning, but I just want to reiterate it one more time. Of course it makes perfect sense that we would presume that if he's the commander, I don't think it gets much bigger than commander. If he's the commander of all security operations, he's the commander over operations that are attendant to the courts, the actual court's security, the personnel's security, the party's security, to whatever degree that is necessitated, but maybe most importantly, the juror's security. That is a reasonable next step to conclude, a reasonable inference from the facts that we were given. But we do know this. He was this same Fanning that was just randomly picked to go report this to, was also the person that was in Ms. Reed's house seizing her phone just months before the trial. He's also the person that was interviewing witnesses or supervising the interviews of witnesses in this trial. He was also the person that was on the text messages between Proctor and his buddies at MSP talking about her and trying to find nudes. We know all of that existed. And yet, we were denied an opportunity, Your Honor, an important opportunity, to simply inquire before this juror was dismissed. That's all we asked. Let's get Lieutenant Fanning in here, let's find out what the source of this is, and let's figure out, is it even remotely true? Remember, the juror never said it was true. But lo and behold, minutes before I stood up to give my summation, that juror's removed. That's the problem. This isn't about court officers and besmirching court officers' reputations. That's not what this is about. This is about what happened at sidebar in the matter of minutes that denied Ms. Reed her constitutional right. There's a couple of other points that I just want to make. Mr. Brennan started his comments by talking about the sallyport video and how unimportant it is. How unimportant that video is. And I'm not going to go through all my points again. The court doesn't need to hear that. But I do want to make this point. He says it's not important. There was nothing to see here. We don't pull videos normally. Yeah, of course you don't pull sallyport videos if you're investigating a bar fight. This was the purported murder weapon. This truck is the thing that the Commonwealth suggests was used to kill a cop. You think the video of it being pulled into the sallyport might be of some evidentiary value? I don't know. Can't imagine why that would be important. Can't imagine why that might have some evidentiary materiality.
A lot of snark here.
But I do know this. I do know this much. There's one guy who thought it was important. The lead investigator. He pulled it all. All of it. He was super convinced it was important. And he's the guy that once pulled it, hid it from us for nearly 3 years. Mr. Brennan spent some time talking about the difference between cracked and missing. Interesting point. And I'm not going to go through a bunch of videos and audios. The court has seen all the pictures and photographs that it needs to see, and the court has a very, very good memory. We've never, ever disputed that the light was cracked at 5:07 or so a.m. That's how it got cracked, is the point. It got cracked on that traverse. And a piece was missing. A piece was missing. Not according to me, according to another agency's sergeant, Barros, who said a piece was missing, but it wasn't completely damaged. Recall that when that light was completely reconstructed with the 46, 47 pieces that were purportedly found, well, they were found at or near 34 Fairview, and then they were reconstructed. Does the court recall what that reconstruction looked like? That taillight was put together almost in its entirety. Almost. Except a piece was still missing. There was a piece unaccounted for. There's a big difference between a crack and the condition of that taillight, which we've now seen, where literally the entire lens material is basically gone. There's a few shards left on some edges, but the entire lens is basically gone. So yeah, it's relevant. And it's exculpatory. The condition of that light when it pulled into the sallyport driveway. And with regard to the inverted video, again, Mr. Brennan says there's nothing to see here. We've got inverted videos dating back days earlier. Then why, if that's such common knowledge, then why did Mr. Lally and Sergeant Butnick, in front of a jury, present that video as a true and correct presentation of what that car looked like and where that car was? Mr. Lally actually asked the question. I don't have a page and site number, but I remember it because I was sitting here. He asked the question, did you see Mr. Proctor? It was something, I'm paraphrasing, something along the lines of, did either you or Trooper Proctor approach that right passenger taillight? And the answer was no. Because on the video that was being played, it looked like the right passenger taillight was the one closest to the jury. And of course, Cooper Proctor walked right around that and went over to the other taillight. Except when you reverse it, you realize that's the right taillight.
Is there a copy of the reverse, the one that you played? Is that in the exhibits for today's motion?
No. The one that's been corrected?
Yes. I'd like a copy of that.
I don't think I have it. Sure. We can get that for the court immediately.
Miss Little, before he's done, please.
Also, he played a video of the grainy video, showing, hey, look, some of these cameras are just grainy in other particulars as well, at other times and places. Maybe, or maybe not. What's interesting is the grainy video that we saw, if my memory serves me, and it's my memory, and it's being taxed at this point, but my memory is the chyron on that video, in other words, the running numbers, was at the bottom. Yet the video he just played is at the top. That's the exact same video. If it's apples and apples, oranges and oranges. Why is that different? That's interesting. And with regard to Ms. Reed's actual statements,
Did they say that?
In that
who put those words on the
interview
bottom?
that was played, or I'm sorry, it wasn't played, it was recited. She said, some of the red plastic is missing. Some of the red plastic is missing. In other words, a piece is missing. It's completely consistent with the condition of that taillight before it was at the sallyport. With regard to the facts that were recited by Mr. Brennan at the very end, every one of those is unsubstantiated. How does he know all that information? Who has he been talking to? And why don't we know about it? If in furtherance of this motion, there was an interview done of Lieutenant Fanning that laid out all of this information about not having contact with jurors and not doing this and not doing that, but yes, doing this and that and the other thing, why is the first time I'm hearing about this when he stands up and tells us? That has been the pattern of this Commonwealth's presentation to this court and in front of the jury consistently. That is the punctuation mark at the end of the sentence. Why am I just now getting that? Why wasn't that appended to his motion? Was there a conversation Mr. Brennan had with Lieutenant Fanning that we need to know about? This is exactly why, Your Honor, exactly why. If this court is not inclined to dismiss this case, and it should, the maladies of the Brady concerning the Brady violations and the discovery violations are so manifold in this case. They cannot, it's irremediable harm. Irremediable harm. This case should be dismissed because of the conduct of the Commonwealth, including Michael Proctor holding onto those videos, hiding those videos, and then others involved with strategizing how to use the videos against us, against the defense, in a murder trial without our knowledge and without giving us the videos. But if the court, in the face of all this, determines that it's either unconvinced at this juncture to dismiss this case, then we urge the court to have an evidentiary hearing. That's what this demands at the very least. An evidentiary hearing so that the court can perfect the record. We shouldn't be guessing at things. And I'll submit.
Any follow-up, Mr. Brennan?
No, thank you.
Mr. Yannetti?
Mr. Yannetti.
Do you want to say something?
I don't think I need to in light of that presentation, Your Honor.
All right. I know you want to do your motion, Mr. Alessi. I cannot imagine that you can summarize it all in 10 minutes, can you?
Did you hear what I heard?
I cannot, Your Honor.
Okay. So I'm not going to have anybody back here this week or next week. We'll hear that on the 18th when we hear everything else. I urge you, Mr. Alessi, to condense it as much as possible, okay?
I will.
I mean, your pleadings are very thorough.
I will do so, Your Honor.
Okay. Not yet. So I gave the parties until, instead of Friday for all the motions in limine, next Monday is fine, but by the following Friday, I want any responses oppositions, any responses to the other side's motions. And then we'll have a hearing on the 18th. Jim, did we put aside any other days as well?
We did, I thought. Just a sec.
Yeah, we did 18 and 19.
That's what I had, yeah.
All right. I would expect that we would finish all the motions in limine in 2 days and wrap up whatever we have here. All right. All right. Yes.
Fox 25 produced the materials at the beginning of March 1st. I went down to see if I could get a copy. It's on a hard drive. I can't simply look at it in the clerk's office.
I'm going to enhance the audio so you guys get to hear what I heard.
Hard drive, or if I can get the hard drive and make a copy and return it.
Does the defense want a copy as well?
Yes, Your Honor.
All right, so you can make copies.
I'll make 2 copies and then I'll return the original to the court.
Okay. All right.
Just before you leave the bench, Judge, I do not want the court to decide that motion for sanctions until I just supplement the record. I could do it in 3 minutes, and if
Go
you
ahead.
don't, you can cut me off.
Go ahead.
Thank you.
Go ahead.
Just briefly, Judge. Yesterday, Mr. Brennan represented to this court that I had made an extrajudicial statement regarding Mr. Morrissey and the federal investigation. You'll recall that I stood up in rebuttal and said that it was in court advocating for my client. He then said court TV is not a courtroom.
So before you go further,
yes.
I don't know if Mr. Brennan was going to give me a court TV site on that. Is
Right.
there one, Mr. Brennan?
I'll have to provide a video. I think that Mr. Yannetti is referring to that comment that was a court comment. And so I intend on remedying that record. There was also a conversation after with court TV.
All right, so provide it to Mr. Yannetti. Mr. Yannetti, I'll give you an opportunity to respond once you get that. But go ahead, you can tell me what you want to tell me now.
Right now, it's out in the court of public opinion that I made this extrajudicial statement. I said specifically I did not. He contradicted me, and that's where we left it, and he said that he would produce the receipts. Now he's admitting he does not have the receipts. There was no court TV interview where I said anything of the sort. That was a Zoom hearing, excuse me, where I was arguing before Your Honor. I would just note, Your Honor, I don't think it makes sense that Mr. Brennan would have done this on purpose because it was so easily disprovable. It's troubling that he would make this damaging accusation without properly vetting it to see if it is true before he attacks opposing counsel. So that was disappointing to me. And I would just point out, and again, I only need 30 seconds. That
You can take your time, Mr. Yannetti. You're not going to be 35 minutes.
Right. I certainly will not be. This new false allegation comes after my colleague, Mr. Alessi, co-counsel, Mr. Alessi, on February 25th, detailed 9 or 10 false statements that Mr. Brennan has made to this court. And I want to make it clear, I don't need an apology from Mr. Brennan. I don't expect one. But I think perhaps he should apologize to the court. He said today, a lie unchecked becomes the truth. And I just would hope, Your Honor, that you hold Mr. Brennan to the same standard that you hold the defense team. And that's it.
I certainly do. So, Mr. Brennan, if you do not have a site, then I need you to let us all know that as well.
I will. It's convenient to retort that there were 10 lies by the court that Mr. Alessi lined up. In fact, I looked at the transcripts. Some of his suggestions that I didn't read the paperwork properly were just wrong.
Do you have a site?
I didn't try to shame him today. It was part of advocacy, and I accept that. There was a conversation, and if you remember, when I related Mr. Yannetti's remarks, it wasn't in relation to 3.6. It was in relation to the fact that they were using the federal investigation to create innuendo that could not be responded to. But I will provide...
For your request for the gag order? In support of your argument for the gag order?
In response to how they had used federal materials that were under seal that couldn't be rebutted to make suggestions. It correctly related to that point, not 3.6. But I will provide the videos. Mr. Yannetti is right that the exact statement that I used was from a court hearing, but then there were subsequent statements made. And so my regrets to Attorney Yannetti, but it wasn't in the fashion of a 3.6 violation. That wasn't the intention. It was to show how they've used these federal materials before the case was closed to their advantage.
All right, so if you have the site, I'll give you until tomorrow afternoon to find the court TV site.
Very well.
If you have it, supply it to all, Mr. Yannetti. So I'm ordering the Commonwealth to, if they have that court TV site, to provide it to all of us. And if you don't, provide that as well. Provide that information. as
Thank
well.
you.
You must
Thank you.
reply.
All right, that's it for today.
That's it for today. It's almost it for today. We've got one more thing to talk about, and that is we're going to play a little bit of replay from two of my favorite sound bites from today. Let's see. Here's this one.
We were standing up at the sidebar, fat, dumb, and happy, not knowing what was going to happen. Wasn't us.
That was the first one, to crank this volume up a little bit. And then I did, just at the end of Mr. Jackson's presentation, as he sat down, Mr. Yannetti said he didn't have anything to add. There was this comment. You guys tell me who. I cranked the volume up so you can hear it clearly. I did not add anything. I just made it louder and clarified it a little bit. Listen to this.
Do you want to say something?
I don't think I need to in light of that presentation, Your Honor.
All right.
Did you hear that last little bit when it gets loud? This part? Apparently, the Hoover Dam is right. So, put a punctuation on that one. Dynamite, something dang right, something like that. Yep. I don't know who said it. I just heard it. All right. Anyway, what we've seen today, this has been what we looked for yesterday. This was the spicy argument. And we knew it was going to be spicy because the defense is literally asking for this case to be dismissed. To be dismissed means to be thrown out, and it cannot be refiled. It would mean that Karen Reed would walk free, and this would all be over. It would end with this motion if this is granted. Now, realize the defense, that's what they ask, and they're saying that any lesser remedy is not enough, is not sufficient. And the judge has agreed in part that she understands why some of the lesser remedies would not be enough. But there is another remedy that the defense sort of said, if for some reason you don't think that's enough because of some of these things, an evidentiary hearing would be the minimum, where we can actually get this on the record, and then they would be able to, if everything shapes up the way they've alleged, they would then be able to use that evidence and say, and now we renew our motion. With all the evidence now before you, we're renewing our motion for a dismissal. It would make it stronger. So either one would be a win. If they get the dismissal, that would be mission accomplished for the defense team. If they get the evidentiary hearing, it's going to sort of kick this can down the road, and then you would need the evidence to actually come in. And you're counting on people to give testimony that would support the arguments you just made to the court, which is difficult because you don't know what they're going to say. You don't know everything, and that's part of the problem. Part of this whole problem that defense has raised with how the state has been conducting some of this trickle of discovery is that we don't know what we don't know. And for the state to stand up and say they never asked for it is a little bit disingenuous. So anyway, Brennan, here's what I'll give Brennan. Brennan seems to be very good at giving discovery when he finds things. It's very bad that he's finding things, and I'm sorry. This was not the horse you rode in on, but this is your horse now, and you have to ride it, Mr. Brennan, and you have to own what came before you and who was riding it before you. So this is a problem. I think the best fact in the Commonwealth's favor is the argument about it being not exculpatory. Right? That basically this is it was a nothing burger as far as the video goes. It was an accident. We didn't think about it because there was really nothing there. But the defense, the argument they've raised contrary to that is, okay, yeah, there might have been nothing there, but doesn't it seem a little suspicious that on all the cameras, on every recording, there was nothing there at the moment there needed to be something there? That everything was blurry, everything was backwards, everything was blacked out or lost. Oops. And oh my goodness, all of the times where they said, we heard that this DVR system records over itself every 31 days. Okay, for someone who knows cameras and knows DVR systems, it doesn't record just over some of it. It records sequentially over it. So the oldest, when the drive is full, the oldest file gets written over first, and it constantly rewrites. That's how it works. You don't have, oops, it didn't rewrite over this one. I'm sorry, that doesn't work. It can't go 4 months down the road and still have it. Oops, it didn't rewrite for some reason. Now, possibly the backup argument, that's legitimate. I don't know how their backups were working, but if they did have backups, when they had to go to the backups to get the information, do you think they should have preserved it then? Maybe? All right. Let's see. Michelle's Mixed Media Madness member for 16 months says, I love this channel and chat. Been MIA, but I hope you'll be watching Arizona versus Nevada Daybell, please. Oh my goodness. I don't know. That's gonna be a circus, because you've got crazy and you've got Sovset, which is a different flavor of crazy, mixed together. It's challenging. Pantuflay, so many noses in booping and not in a good way. Thank you very much. Selena K, thank you. I saw the text. I was going to share it with people when we had a break, but you sent a super chat sharing the information anyway. Selena, the new x-ray that she's done, torn meniscus along with bone, pulled away with it. Oh, that sounds painful. I have to be non-weight bearing for 6 weeks. Depending on what my MRI shows, I may have to have surgery. Selena, hopefully for the next 6 weeks you can hang out with us. That's all I can say, is we can try to make it as least miserable as possible. That's what I'll try to do. Out and about with my Diane. Great to have you here. Welcome. Thank you for the super chat as well. Bri Bear, welcome to the jury. 10 months there. And Selena K sent the text to the burner. I got that, and I just was slow in responding. Let's see. Where are we at today? I've got to fix that audio so it's not so noisy in the background. Hey, Mrs. R.A., how are you doing?
I'm just curious if you could do like a summary. Catch me up. All the things that are going on.
You'll have to wear headphones.
What?
And then you have to take a mic. If I'm going to give a summary, I need to be able to, talk to you. Do you have headphones?
There's some on this ground.
I saved them on the ground there for you. Here, you can take this mic. And then swing around over here where we can see.
Okay, that's where I draw the line.
Okay. Apparently, you're not on camera today. All right. Quick summary. Today was the spicy bit of what was...
Actually, I'm going to, because I can't see your eyes.
I know.
Okay, there we go.
That helps. I can't see you either. You need to move the skeleton.
I know I have to look
Mr. Bones.
Bones to get to you. That's weird.
And now if I lean back and then you move over. There we go. We can. There's my wife. She's lovely. All right. Today was the spicy bit of the hearing. It's a pretrial hearing with Karen Reed. They are arguing everything leading up to the trial, as they normally do.
Is this the argument about whether Yannetti, which side is Yannetti on?
Yannetti's on Karen Reed.
Okay, but not him, the other dude.
Brennan or Alan Jackson?
Alan Jackson. Is this the one about whether Alan Jackson gets to stay or not?
That was sort of like, it was Brennan sort of perpetuated that there was a fraud on the court and they had lied about something, and Alan Jackson got up and spelled that out with a timeline that was pretty ironclad, and the judge did not like his answer, but
because
it's a legitimate answer. And
it's against her.
It doesn't give the state any grounds to really punish him.
So he won.
I think he won that one.
Okay. So, and who's Brennan? Who is this guy?
Brennan's state. He replaced Lally. So Lally,
where did Lally go?
He's still there, but Lally moved over to like the silent chair. He doesn't get
He's
to
in the
talk
quiet
much.
box? Okay.
So Brennan's the new special prosecutor.
Why did that happen? Do we know?
Probably because this is a cluster
okay.
of comedy of errors.
Yeah, let's go with that one.
Okay. So we have that.
Okay. All right. I think I'm caught up. Okay.
This was a hearing to address the defense's motion to dismiss for extraordinary government misconduct.
Which is specifically, you didn't give us the video of the sallyport and anything else? You just don't talk to us
yes,
ever?
Yes, you dismissed, as soon as you found out there was a juror in our favor, you dismissed them.
Is that legit?
No,
is that really what happened?
The defense wants to swing the story that way, but there was an issue. Somebody I don't know exactly what happened. Somebody identified the juror or knew it was a juror or said something to a juror out in public on lunch, and word got back that something happened, and they, probably out of the word abundance of caution probably came up, they released the juror. And the defense is saying, that was our juror.
How did they... You wouldn't know that. How...
It got around, and it got around to...
I mean, how would you know if the juror's your juror? You shouldn't know that.
They can see, they can watch the jurors because they're in the courtroom. So body language, I'm sure they had an idea that they thought somebody might have been sympathetic to their cause.
Okay.
Anyway, it turns out that apparently the defense's argument that the way the person, the detective, the lead guy over the security, how the argument came in, or the information came in against the juror through him, that was a problem because he was also the guy that confiscated her phone.
Okay.
He's involved in
I'm sorry,
Mr. Proctor's.
To everybody on here, I know you all know this, but I'm having a hard time locking it down in my head time-wise. So what he's saying is a juror is out eating a hot dog, somebody comes up and talks to him,
hey,
soils their...
Free Karen Reed, something like that.
Yeah, okay.
I don't know what happened.
Okay, but something that makes them...
An interaction,
unfit for service.
An interaction identified somehow. We don't know. That happened at sidebar.
Okay. And what? That happened at sidebar? Oh, explaining it happened at sidebar.
Yeah.
Okay. And then the next thing that happens is somebody witnesses this and goes to the officer who's in charge of the jury and says, hey, this happened. And this officer also happened to be in way over his head when it comes to trying to prosecute Karen. Is that...
I think he was Mr. Proctor's boss. He was involved directly in the investigation. Yeah, so it's like,
not
hey, hang
unbiased.
on, you're the one. It makes it look like, from the defense's standpoint, this guy who clearly has an interest in making sure Karen gets convicted, because that's his job, right? He's doing his job to put this forward. He's the guy that says, oh, by the way, kick out this juror because she's looking like she's leaning defense. That's what defense wanted to say.
Okay.
Turned out to be a nothing burger.
Because
he wasn't involved.
Okay.
Yeah. But the defense didn't know that.
Is he really in charge of the jury? Is that...
No.
Okay, good.
No, and defense didn't know that either. What did you just break?
Might have been the skeleton. Sorry, you have two skeletons now. I'm sorry.
I distinctly heard skull rolling towards that side of the studio.
The skull's over there now.
Oh, I see it. It's on the floor.
Sorry.
All right, there's been a murder.
Sorry, guys. That was me.
Anyway, so that was a nothing burger. The court sort of challenged the defense on that, saying, hey, did you file this knowing that it wasn't a problem? And it turns out that they didn't know, and every time they filed and said things, it was to the best of their knowledge at the time, and that we found out that was not accurate later.
Okay.
So
Bev was saying, stop wasting my time, and they're like, no, we weren't, because...
No, Bev was saying... Did you lie to the court, was what she was saying. And their defense is saying, no, we didn't. And if you look at the dates and the timestamps and look at the transcripts, this is how it went down.
Okay.
So that happened. And then the big one was this continued revelations from the state, the Commonwealth, to the defense on videos. Hey, we found some new video. It's during trial. Here it goes. Oh, we found it's after trial. Here's some more video. Here you go. Hey, guess what? Yesterday. Here's some more video. That's a problem.
Do you hear that?
I am hearing it ringing.
Oh, just went away?
It did.
Okay.
Wasn't me.
We both have synchronized tinnitus. Okay.
Yes. Anyway, it's all this argument. It was pretty spicy. It's pretty. It's pretty heated.
That's valid, right? You can't.
Oh yeah.
You have to disclose everything. You have to show
a level of outrage at this. I don't know how a lawyer would be able to say, I move for a dismissal of the trial. Just, you've got to show I'm mad as heck and I'm not going to take it anymore. Sort of to some degree to sell that argument to the judge. And
well, they've all been mad as heck over everything, so that's lost some of its punch power. But my question is this valid? Is this argument actually factually correct that the prosecution has not been giving all the information to the defense?
Yes. And we know that it's mostly been Mr. Proctor. He's been thrown under the bus. The lead investigator, he pulled the videos. He's the one that pulled the sallyport video. He had all those. So he knew it was important to him. He had it in his file. He reported on it.
He knew it was important to him? Then why wasn't it a part of I want to say disclosure. That's not what it's called.
Discovery.
Discovery. Why wasn't it a part of Discovery?
Great question. It should have been.
Thank you.
And as soon as they found it, they turned it over, says the prosecution team, says Mr. Brennan.
Mr. Brennan is saying, it's not me, it's Proctor. You can't hold me accountable for that, deadbeat.
The bus has gone back and forth over Proctor several times today.
I must say, he does not get any sympathy from me. And yet, it is really, it's not cool either, because that makes it so that the prosecution is like, oh, we're not guilty.
Yeah. The problem is the way the law is written. Mr. Proctor, who has an office in the district attorney's building.
Currently?
That's where he worked.
Okay. Oh, back then.
So I think he still does. He is part of the team. And the state, or the Commonwealth, is responsible for everything the team does, including the Canton Police Department. Everybody on their side, all the investigators, all the police, all the prosecutors, they are responsible for all of them. When there's an order to turn something over, all of them have to turn it over. If one doesn't, they're all guilty.
Right.
And
Which
Mr.
seems
Brennan,
like, oh man, but at the same time, it's like, well, how else would that work?
Mr. Brennan, at the beginning of his remarks today, stood up and said, yeah.
We messed up?
Proctor should have turned it over.
Proctor, that bad. Well, he is,
Proctor guy.
actually. But
as soon as I found out, I fixed it. But, yeah. So it's an admission. It's an admission, and it's a problem. The question is it big enough to require a dismissal?
It was for the actor. Remind me his name. Alec Baldwin.
Okay. Well, that evidence in his case was exculpatory. And that's the factor here. Is it exculpatory? The issue we have, and the defense has raised this, is the evidence, when it finally was turned over, is in some cases years after it was collected and
Well, it sounds like there was some more that came out today. Like, it's still...
most of what's come out lately has been like records of how things were collected and who stored it and where, and accounting for things. But there was video that came out fairly recently, most of it non-usable. I forget what I was saying there. Exculpatory. The problem is the video is grainy. It's missing parts. It's blurry. It's blacked out. It is what it is, and a lot of it is just not usable. Now, the defense is saying that in and of itself is a problem,
suspicious,
because all the cameras at the appropriate time are missing the video that we need.
When you say appropriate, you mean
the 42
key
minutes.
moments.
The 42 minutes, yeah, when that car showed up and it was
That's
brought into the sallyport.
inappropriate.
That's defense's argument.
Okay.
And they're saying, Judge, you can't say, no, we looked at the video and it wouldn't have done you any good anyway, so just dismiss this. Because
that's what happened in Baldwin's case, right? They were like, oh, you don't need that. That has no bearing on this case.
It had a bearing in that case. And this arguably is what the defense says is the fact that it is missing and all of it is blurry and all of it is, in this very moment, all the cameras at the police station glitched,
right.
That in
very
of itself
Jason Bourne
is proof. That is enough to show that the client was prejudiced. She's prejudiced in how she could defend herself because they couldn't cross-examine, say, Proctor, for instance, on the stand.
Sorry, go back. The client is prejudiced?
Their client.
Whose client?
Defense. They work for Karen Reed. Yeah.
She's prejudiced?
There was prejudice against her.
Okay.
Sorry. Like, I used the word backwards, right?
I don't know, but I got confused.
Prejudice has been perpetuated upon her. Let's do some alliteration.
Previously and ponderously. Got it.
And I'm going to pontificate on this point. Anyway, that's about where this ends up today. No ruling has been made. The judge has asked, not for a lot. There's not a lot of work left over. I think a couple things that Miss Little has to bring as far from the defense side, basically citations. The judge wants citations and examples of certain things. She says, show me where that happened. I want the transcript. What page is that on? Some of that has to be produced. At the very end, Mr. Brennan, at the beginning, Mr. Brennan made an accusation against Mr. Unetti that he made an out-of-court statement to Court TV, blabbing when he shouldn't have.
I have to just pause for a second. Was it Court TV? Was it Law and Crime? Was it you, Scott? Or was it really actually Court TV?
I'm pretty sure I haven't had any of them on my show.
No, 100% not us. But I'm just saying, Court TV gets quoted a lot. Was it really Court TV?
Well, a lot of times they'll cite Court TV because they're very often the pool camera.
So
but this was an interview. This was an interview. Anyway, Mr. Brennan, as he makes this point, he argues this, and Unetti gets up at the very end and says, just for the record, I made that point in a Zoom meeting in court with you, Judge. So it's possible somebody could have used the video and it might have shown up on court TV or shown up somewhere. But that was not an out-of-court statement. And to use that as, here's an example, this is why we need a gag order on this case, and defense should not be allowed to talk at all.
Because, okay, so defense has been talking a lot.
Oh, nonstop.
So they want it to stop because the rest of the world, let me finish that sentence. The rest of the world is absolutely appalled at the way that Canton Police Department handled this. And it makes me wonder if that's why she doesn't like, remind me of his name again, AJ, what is his name?
Alan Jackson. He's like a singer, but he's from California.
Is that a singer?
Pretty sure there's a country music star called Alan Jackson.
Is he old? I don't know that one.
I think you probably know his songs.
Oh, okay, probably. Anyway, my point is, he comes in out of not here, and he's like, are you people crazy? You can't all be drunk all the time. You can't be doing the things that you're doing. This is absolutely unacceptable. And to have kind of you're not one of us come in and call us on the carpet, I think there's a chip on the shoulder attitude there.
There's been allegations that the townies, you're not from here.
Right.
There's a strong, feeling of you don't belong.
And that is that applies to all of the media. None of you belong here, right? Oh, yeah. You guys have no right to come in and look at the way that we are living our lives and trying to tell us.
Don't judge us on how we drive drunk. We've been doing this for years.
Solo cups are the next thing.
And we know when it's snowing. So, yeah.
Yeah, but I do get that impression that there's such a strong sense of everybody in the court saying, just let us deal with this on our own because we know how to do it. And the rest of us are looking at it like, but do you?
Yeah.
I don't know.
I think defense has a strong argument here, but I don't think the judge is going to allow the dismissal. I don't think because they can't prove the exculpatory nature of the evidence.
I do not believe that she should be able to make that call. Somebody, some third party who's not interested in this case should be able to make that call because it's saying, hey, Bev, you screwed up. You can't judge yourself. I'm never guilty in my own eyes.
Sometimes judges make that call. Sometimes judges recuse themselves. Sometimes judges do say,
sometimes they do.
Like they did in Alec Baldwin's case, hey, you know what? This is wrong. The state messed up.
The state did, though. At no point was it like the court, messed up. There's a lot of pushback directly toward Bev. It's like the court messed this up, the court missed this, the court allowed that. And so it's much more personal with her than it was with the Baldwin case. What?
Alan Jackson sings Chattahoochee. You've probably done a line dance or two back in the day. I
have, actually, okay. But it is back in the day.
All right, that's where it ends up today.
So now we're waiting on the ruling that says we're going to dismiss the case, which won't happen.
Right. We're waiting on a couple things.
Okay.
There was a federal hearing this morning.
About
the Karen Reed and her lawyers were in, and they're arguing double jeopardy, basically.
Because how can you argue that, though? Because it was a mistrial.
Well, they're arguing that it wasn't. They're arguing that the jury was insufficiently instructed. They did reach a verdict, and she should not be facing...
so just on those counts, or for all of them?
Just on those counts.
Okay.
So that was argued this morning. So that decision has to be made before trial starts, which is basically the end of the month. So that decision will come in the next couple of weeks. The judge's decision has to come in on these things in a couple of weeks. I imagine the ones about, say, like a gag order would be fairly quick because the sooner that gets decided, the less damage can be done.
I hate to say it because, you're the media, but looking at this case, I'd be like, oh, I would gag it so fast. It's gotten out of control. It's
been fun. Anyway, interesting. I like the courtroom drama. These are top level attorneys thinking on their feet and working fast, and I love it.
Oh, and props to the girl who's like, I don't know her name, but there was like, she'll do that.
Miss Little,
she'll take care of that.
She is amazing.
She'll crank that out for you.
Remember the who was it that was in the Maya case that became like past the bar during the trial? She's like that version, but like farther along on her career. She's phenomenal.
Less people are talking about how amazing she is. Like she doesn't get to announce anything in court, but man, she's like she gets thrown things all the time. She's like, no problem.
Yeah, she's really good, and she's grown a lot. If you've watched the trial, she started out quite hesitant and nervous. I mean, And now she's made some really sound arguments and counterpoints.
Oh, she does speak.
Yes.
Oh,
yes. She'll stand up and argue things.
Oh, that's interesting.
All right. That is where we end it today. I know there's some new stuff, some new documents that just dropped in the last couple days. Let's see. Brian Koberger, order granting leave to exceed page limit. Uh-oh, we're going to get a big one.
We need more pages.
What's the limit on this one? Hang on.
Did you know that we're in a tornado warning watch, whatever it is?
Yes.
The less scary one.
Yes, and Weather Watch is like, I'm surprised he still has power. I'm just not even going to jinx it by saying anything.
Oh. But Weather Watch, we don't have a downstairs bathroom. That has nothing to do with the tornado.
Well, maybe I can fix that.
Yeah, that'd be awesome.
There's breaking news in the BK case. I'm looking at this right now. I'm looking at BK actually right now at the filings. We've got a couple things. First of all, we know that Brian Koberger is going to, or his team's going to argue to have the death penalty removed because they're saying he is on the autism spectrum. And that should be grounds to make it unfair.
Wait a minit. The autism spectrum is huge.
The spectrum's massive. Most people fall somewhere on it.
Yeah.
But I don't know. There'll probably be some argument there. They probably talk to something. Where am I located? I am in my house, equestrian. I'm in North Carolina.
Under some seriously hot lights. I'm not even under the lights.
I'm cooking.
Hot in here.
I'm cooking. That's the Brian Koberger case, starting in August, I believe. August 12th? Is that the right date? That was the Idaho 4, the 4 college students that were stabbed to death in their apartment, and it's going to be crazy. That's going to be a long case, and it's going to be a crazy one. But let's see, was that the breaking news that you wanted to talk about in that case, Angela? I think there was something else. There was a filing, something about mixed DNA. Did you guys see the news about that? Okay. Skeleton brothers were declared legally dead. 3-person mixture in the DNA found underneath victim Madison Mogan's nails.
Did you say 3 people?
3 people mixture under her fingernails. That's interesting.
Mm-hmm.
Remember what Brian Koberger said when he was arrested?
No.
Has anyone else been arrested?
That's what he said.
You guys, is that just me that remembers that?
Well, in this room it is.
Is there any other suspects, or is there any other people?
Oh, any other suspects though?
Has anyone else been arrested or something like that? I seem to recall that. Let's see. That's in a court filing. That's in court documents. Let's see. Motions in limine. It might be a redacted document now. So much is redacted and
How do they get away with that? I mean, I get that they would redact personal information.
They don't want this out in the public, to
mess up the jury.
Before the jury hears it in court. Because some of the information, quite honestly, is just not admissible in court. And it's either prejudicial or it's not probative.
But that's interesting because that's usually the case with these things. They're talking about them on paper for a long time, but they usually let it all out in public. Now they're not. That's interesting.
Yeah. Crazy. I'm not the only one. You guys are saying, yes, he did say that. I recall that. BK docs open to the public, I heard. Yeah, if you want to look for the BK docs and go through them yourself, because there are a ton of them. Let me give you a link. Actually, just search go to Google this yourself. Type in Idaho court documents, and the top page answer I get says Idaho judicial cases of interest. You click on that page, and then you click on trial court cases, and it's the only one they have is Brian Koberger right now. And then you can peruse, or you can go to Discord where they've done all this work for you. DSN gifted a membership. Thank you very much. Lake John, congratulations. You are now a member. You're now one of us. You can never leave.
One of us.
All right.
Whoa! Oh.
My desk started moving.
My goodness.
I didn't realize I bumped to the
I was like, it's a tornado! Holy cow. It's put pushing everything down.
Going back up. All right. I think that's all for today. That's all. That brings us to 4:30. It's a little bit early. My heart's racing. I'm not sure if I was more nervous by the desk giving way underneath me or you yelling when it did the same for you.
I didn't yell. I simply explained calmly.
Should we roll the tape? Should we roll the tape? All right. That's awesome. Winds in Arkansas are outrageous, says Cindy.
Great.
Yeah. I don't want to know that. That means they're coming this way.
They are coming this way.
Sloth Life says, I have to ask Recovery Addict before I go. Does Mrs. Ari like your pin and coin?
Yes, I think they look very cool.
Yeah.
I especially liked the skyline that was embossed. I thought the details on that are just so cool.
You missed it. I did a full show and tell, Sloth Life. I'm not sure why you were late. Frankly, you didn't ask for an excuse. You didn't ask to be late. You're going to have to watch on the rewatch. But seriously, thank you very much. That is so amazing. I love it. All right. Yes, BK did say, has anyone else been arrested?
Interesting. 3 people, though?
3 DNA. Okay, that's under the fingernails. Okay?
So, yeah, but...
The idea is that in a fight like that, self-defense, there's scratching, there's clawing, there's, there's other ways it can get there. And, we're not going to go in all the ways that DNA can get under your fingernails. But having 3, especially if it doesn't match anyone else in the house, that was going to be interesting.
Yeah, it is.
All right, tonight when you go home, please hug the people you love, smile at someone, make their day just a little bit better, and please stay safe till we go live again tomorrow morning with more court watching. We will eventually get back on a full case here because Karen Reed stuff is done till the 18th
of March.
There's going to be some documents drop, and we might take a look at those when they drop. But I think we're done till the 18th. On is there something on Monday? I don't know. We'll have to check.
The 9th.
I don't know. You guys have a good night. We'll see you tomorrow. Bye-bye.
In front of the Walmart.
Because he's the guy.
Thank you, sir. You're my new best friend.
If they didn't, I would lose my mind.